Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and the Honorable Court.
You may be seated. Morning, Mr. Vance, you ready?
Yes, Your Honor.
Let me approach.
May it please the court, my name is Robert Vance, and I represent the appellant Phyllis Weaver in the first case. I will be addressing a few of the issues before the court, but I will leave for EEOC counsel to address the issue that she briefed in this matter. This case, Your Honor, first I will address the issue of whether this court has jurisdiction over the appeal, which the parties submitted supplemental briefs on. It is a position of the appellant that this court does have jurisdiction over this appeal because the order of the district court was a final order of the district, was a final order. The two cases that the court referred to counsel to brief, this case is more like the BPJ case than the Porter case.
Before we get into that, can I ask you about a different jurisdictional question I have?
Sure.
So you are asking us to review some things about the transfer that happened in the first court. This was Pennsylvania, I think.
Yes, the court was the complaint was filed in the United States District Court for the Eastern District of Pennsylvania. However, Your Honor, at this point, the issue of whether or not the judge in the Eastern District did or did not do something that was required, the appellant is not addressing that issue. I'm addressing the issue of what occurred with regard to the district court in North Carolina.
Well, I thought there was, and if I'm wrong, I'm totally sorry. Wasn't there a section in your brief that was arguing you should have been able to take jurisdictional discovery in Pennsylvania?
Yes, Your Honor, but practically speaking, it really doesn't matter whether the case is tried in Pennsylvania or North Carolina.
You don't need to rely on that because there's nothing to that argument, is it?
Well,
I mean, really, you can move on.
Exactly.
You're not going to get anywhere with that.
Precisely.
Yeah, okay.
All right, so the issue of whether the court has jurisdiction, as I indicated, this is a final order of the district court in North Carolina. This case is like BPJ as opposed to Porter, because the district court judge in North Carolina, although the complaint in this case contained 3 counts, a claim of race discrimination under Section 1981, a claim of race discrimination under Title VII, and a disability claim under the ADA. The district court addressed only the defendant's 12B1 motion to dismiss with respect to the Title VII claim and the ADA claim based on the 90-day filing within the Notice of Right to Sue requirement. The district court never addressed the Section 1981 claim, but when the district court entered judgment, it closed the entire case. So,
Didn't that happen in Porter too?
well, it did in Porter, but the difference of Porter is that in that case, that was a habeas petition. In Porter, the district court there made a statement that the appellate court in Porter made the statement that the district court in Porter did not address a central component of a claim that had been raised in the habeas corpus petition. That's different than this case. Here we're talking about the district court not addressing an entirely separate and distinct claim altogether, not a component of a general claim, of a total claim.
So why does that seems like it makes the jurisdictional problem worse, not better? I'm not following why that makes it a better case for appellate jurisdiction.
Because in Porter you had a habeas petition where that listed a lot of grounds for why the petition should be granted. The district court addressed most of them, but not all of them. And in addressing most of those claims, the district court decided to dismiss the habeas petition. However, when it came up on appeal to the Fourth Circuit, the decision was that the district court erred because although it was not a final order because there were certain aspects of the habeas petition that had not been addressed by by the district court, whereas in this case, we have 3 separate claims that the district court in North Carolina addressed, or actually 2, only 2 that the district court in North Carolina addressed. And despite its decision with regard to those claims, which of course we contend was erroneous, it dismissed the entire case without even mentioning, without even considering whether the 12b6 motion that the defendants had made with regard to the Section 1981 claim was legitimate or not. But it closed the case, the judgment. The judgment actually closed the case, so there was nothing left for the district court to do. The appellant my client had no alternative other than to appeal because there's no relief that we could get in the district
Why,
court.
I mean, to take what the court said in BPJ, why couldn't your client have said motion to correct or alter amend? Like, why wasn't it open to your client to say, dear judge, dear district court judge, you do not seem to have addressed the 1981 claim. Please address the 1981 claim. You just said there's nothing you could have done other than appealing.
Well,
why couldn't you say, dear district court judge, I fear you may have overlooked the 1981 claim. What do you think about the 1981 claim?
Perhaps. However, we chose to appeal the decision in its entirety because the district court closed the case and made erroneous rulings with regard to the Title VII and the ADA claim. And it is a final decision because as this court has stated, I believe in the BPJ case, you have to look at the substance and not so much the form. So the substance of what we have in this case is a dismissal of the entire complaint regardless of whether one claim of the complaint was addressed or not.
I have one last question about this, then I will let you get to the merits, I promise.
Sure.
But when BPJ says substance, though, like you have to look at what happened in BPJ. So in BPJ, essentially the plaintiff had 2 claims, a Title IX claim and an Equal Protection Clause claim. And the district court wrote a whole long opinion explaining why, in its view, the Title IX and Equal Protection claims failed as a matter of law. And it did so on grounds that were clearly applicable to all the defendants because, like, it was, this thing does not violate Title IX. This thing does not violate the Equal Protection Clause. And so when you read the district court's opinion, there's no conceivable basis that the district court overlooked a Title IX or Equal Protection claim. And there's no conceivable argument. Like, I guess I'm trying to think about what the parties would have done in BPJ if they went back to the district court the day after the district court issued its decision in BPJ and said, like, well, technically you didn't dismiss the school board. And the court would be like, I just read a 70-page opinion explaining to you why this policy doesn't violate Title IX or the Equal Protection Clause. So I also hold that it doesn't violate Title IX or the Equal Protection. Like, what would the district court have possibly said if the board had gone back the next day? Whereas here, you could have gone back and said, I don't understand why you dismissed the 1981 claim because the only basis you gave for dismissing Title VII, lack of exhaustion, doesn't apply to 1981. Judge, I'm genuinely confused why you dismissed the 1981 claim. I don't understand. And that seems like a pretty big distinction between this case and BPJ.
I would have to admit, Your Honor, that is a distinction. However, I believe the plaintiff can elect what to do in that circumstance. In other words, go back to the district court and ask for clarification of the order that, or I should say, of the judgment that closed the case, because as this court has indicated, this court deals with judgments, not opinions. So the plaintiff could have gone back and asked for that, or simply appeal to the Court of Appeals and make the arguments here, which we're making here with regard to the exhaustion issue. So with all due respect, if I can get to that.
Of course.
The bottom line with regard to the exhaustion issue is the question of whether or not the complaint was timely filed after the issuance of the notice of right to sue is quintessentially a question of fact. And the district court, in its own opinion, pointed out issues of fact that, unfortunately, it presumed adverse to my client. Insofar as, for example, when the notice was actually...
Well, that's the important fact, is when was it received. The question being, if there's nothing there, you then go under the presumptive rule of the 3 days.
Right, however, I'm sorry, Your Honor.
You go ahead.
I'm sorry, but you don't get that presumption unless you can establish that the notice was properly directed. And that's an old Supreme Court case, Hagner versus United States from 1932. And properly directed in this instance, based on the facts that were before the district court, there were numerous questions about whether the notice was properly directed because my client had moved from the time that she had filed the
You
EEOC.
can't go anywhere with that. There's a requirement that the client has to tell them where they are.
That is true. However, the properly directed prong of that presumption is a question of fact. But more importantly, the issue is really when did she actually receive it and when was it actually sent? Because as indicated in the brief, the notice of right to sue had numerous notations on it. One September 2nd, one of September 19th, and then you have a notation of October 3rd of 2019. So if in fact the notice had been sent out on October 3rd, then filing on December 27 of 2019 would have meant that that filing was timely. And so those were the questions, those were the issues of fact that the district court in North Carolina should have said, okay, there is a dispute as to these issues. I'll defer ruling on the defendant's 12B1 motion to give the parties an opportunity to take very, very limited discovery on those two issues.
Well, what
When
about
was-
the document that the EEOC director, assistant director, whatever, sent, that essentially said it was mailed on a specific date?
There's, as I indicated in my brief, I've never seen that certification in the record. And maybe I missed it, but I didn't see it. And that in itself is a question of fact. If there's a certification that is contradicted by the actual notations on the notice of right to sue, then the plaintiff should have been given the opportunity to probe those inconsistencies. And the district court could have simply deferred decision on.
So you're saying the certification is separate from the document?
I'm saying the certification, which is what the district court relied on to say exactly when it was mailed, whether or not the certification is accurate was a question of fact because of the
When he
notation.
signs that document, the EEOC director, isn't that a certification that it was mailed on that date?
Perhaps, but under the factual circumstances of this case, with all of the other indicia of no, it was not mailed on that date, my client should have had the opportunity to probe that issue. I get 5 seconds. Oh, okay. I don't really want to cut into my rebuttal time, which I appear to be doing. So I'll stop at that point.
All right, thank you, Mr. Vance. Ms. Ocolina?
Good morning. May it please the court, my name is Ann Noel Acalino for the EEOC as amicus. We weighed in this case to address 3 discrete issues. The first is we argued that the 90-day filing requirement of Title VII and the ADA is non-jurisdictional. Second, we argued that as a result of that, it was a mistake for the district court to resolve the 90-day issue on a Rule 12b1 motion to dismiss. And third, we noted that Section 1981 is not subject to Title VII or the ADA's 90-day filing requirement, and it would have been an inappropriate basis for dismissal of Ms. Weaver's 1981 claim.
But the
So-
third one is a given, isn't it? That's a given. mean,
I
it's-
do
it's
think it
not-
is a given, and I'd rather
It's
not.
not subject to the 90-day requirement. And
No,
what-
absolutely, and that's what we noted in our brief, so I wasn't gonna spend time discussing that unless you had any questions
Just
about it.
two threshold questions. I think I know the answer, but I just want to confirm. Does the government have a view about whether we have appellate jurisdiction?
No, we
Okay.
did not take a position. We saw your order, and we called the clerk's office to confirm whether this court expected or anticipated that we would file a supplemental brief. We were told no, so we did not do that, and I can't speak to that.
Sure. And then the only other one is, does the EEOC have a position about whether the right to sue letter was in fact mailed on September 20th?
We do not think that there is evidence here to confirm that it was actually mailed on September 20th, 2019. Our brief explains that because it's non-jurisdictional, the burden is on the defendant to establish the timely filing requirement, which is in the nature of an affirmative defense, much like a statute of limitations. We think that it was inappropriate, would have been inappropriate to dismiss on a 12b6 motion in the mine run of cases where there is
Right.
a dispute about the date of
Okay, so
actual
let's
receipt.
just hypothetically assume we get to the merits decision. Do you think that the date on the letter, it would be evidence of when it was mailed?
I think in a routine case where an employer points to the 90-day requirement and cites to the right to sue letter and notes that it states on its face the day that it was mailed, that would probably be sufficient. But this case is not the mine run of cases, and I'd like to walk you through that. First, Judge Nguyen, you asked
Before
about.
you do that, I want to make sure I understand EEO's position on the date.
Yes.
There is a document signed by an EEOC commissioner. so
Yes.
That has a mailing date on it. And you're saying the EEO's position is that when that document comes out, that's not a certification by the EEOC of the mailing date.
That's correct. I think it's a misuse of the term certification. There's no declaration or affidavit in the record
The
that
signature,
says.
the signature the judge found.
The
was
signature
certification.
is a stamp from our acting district director of the Raleigh office, Thomas Colclaw.
Certifies it.
It says on behalf of the commission. It doesn't say I certified that this right to sue letter was put in the mail on September 20th. It does say date mailed, so I don't want to
I
dispute
guess I'm
that.
thinking about EEOC in terms of where you go forward with this. You're telling me that a document from an EEOC regional commissioner that says that's the mailing date, that's not sufficient in EEOC's mind. I'm not, you're not aligned with the client in other ways, you chose not to go forward to it. You gave a right to sue. So you're not pursuing this case. You could have, but you chose not to. I'm trying to see what EEOC is in terms of what a mailing date is and what is it proof.
Judge Wynn, if I could just remind you that the key date is not the date that it was mailed, but usually the date of receipt. And when the date of
But you
receipt,
determine the date of receipt based upon when it was mailed. You have a 3-day presumption.
Your Honor,
What is gonna be your beginning point if you
I'm-
don't have something there?
and in the mine run of cases, I do believe that when it says the date mailed is on the right to sue notice, we would go with that. We would take the 3-day mailing rule, so I'm not disputing that.
That's a mine run of case.
In the usual case. But an unusual case is one where the plaintiff has pled in the complaint, and you must assume that is true under Rule 12b6, motion to dismiss, the joint appendix, the page 6, the complaint at paragraph 3, she pled that I filed suit within 90 days of receipt of the right to sue letter. Now, the other piece.
That's not sufficient. She has to state when she actually received it.
I have to disagree, Your Honor. I think it's an
Where's the
affirmative
case law that
defense.
says she simply can make a conclusory statement that I filed it within 90 days, that's enough?
Your Honor, I don't understand your precedent to require a plaintiff to plead facts
I
in the
don't
complaint
understand
that go
you
to an
not giving me
affirmative
a
defense.
case that says that.
About the affirmative
That
defense doesn't have
says,
to be
that's
pled?
all you have to say is I filed it within 90 days, and it doesn't matter, even if you got evidence, if the record doesn't show it anywhere else, and you got one document that says it was mailed, which is in the record, then how is it that you simply can make a conclusory statement says I mailed it within 90 days, and that's enough?
Your Honor, I think you're unconvinced by my arguments, but I would point you to the
I'm not
Goodman case.
unconvinced. I'm trying to get you to explain my point. I'm not being argumentative with you. Understand that. I want to know because, and the reason I'm telling you this is because I can let you argue this on and on. I'm trying to help you make a case because if I'm telling you we're going that way, pull me out of this hole I'm in. And I just said, you are saying it is sufficient to make a conclusory statement alone that says, I did this within 90 days. And I don't believe the case law says that, but you correct me and tell me where it does.
I believe the Goodman case from 2007, your en banc decision, discusses this and says that an affirmative defense, such as the statute of limitations, does not have to be pled in a complaint. So she did not have to plead the date of receipt of the right to sue notice. She pled in the complaint that she did file suit within 90 days of the right to sue.
That is exactly correct. An affirmative defense does not be, the defendant has to bring it up. So the question is, did the defendant bring this up as an affirmative defense?
I agree that the defendant did bring it up.
That
Walgreen brought it up.
creates the issue. I'm not talking about whether she has to plead. That's your whole point. Your whole point is it's not jurisdictional, because if it's jurisdiction, you got to put it in that complaint. I understand what you mean by why you are here, because you don't want it to be jurisdictional. But if it is an affirmative defense, when the defendant pleads it, it throws the issue out. I mean, it's there.
Well,
There's no obligation on the plaintiff to plead it. I agree with that.
if I could have an opportunity, I'm past my time.
May.
I think that there's 3 or 4 things that you should look at to understand that there is a dispute about the date of actual receipt of the right to sue notice. The first is the right to sue letter itself with a handwritten notation in the upper right-hand corner, CW entered October 3rd, 2019. We know from the brief that Walgreens filed below that the CW refers to Christina Woodworth, their legal coordinator. Now, it seems passing strange that a letter mailed on September 20th, 2019 would not be received at their office. They were also copied until October 3rd, 2019. Second, you have Mr. Vance's declaration in the record where he attested under penalty of perjury in paragraph 3 of his declaration that he did not receive the right to sue notice until October 2019, which would have been 10 days after the date of mailing. And then third, we have the investigator's letter in the record, which is dated September 9th. It went out with the right to sue notice, which says it was mailed September 20th, which gives more reason to question exactly when the right to sue letter was put in the mail.
Do we have any evidence as to when she actually received it?
I think the answer to that is no. You can ask Ms. Weaver's counsel about that, but there is no specific evidence in the record from her, but that is all the more reason why there should have been some limited discovery. The deposition of Ms. Weaver could have been taken, and she could have answered that question. I'm over my time. Do you have any more questions for me?
Thank you, Ms. Aquilino.
Thank you.
Mr. O'Halloran?
Good morning, and may it please the court. My name is Shane O'Halloran, and I'm here on behalf of Walgreen, the appellee in this case. Given there's a question of appellate jurisdiction here, I'll plan to address that issue first and then move on to the merits. But if there's another order in which the court would prefer that I proceed, I'm happy to take your direction on that
So
point.
can I start with the merits question that I think implicates jurisdiction?
Of course.
Do you agree with the EEOC that, I think you do based on your brief, that there is no exhaustion requirement under 1981?
Yes, we do.
So when I read the
dispute
district court's order, why did the district court dismiss the 1981 claim? Like, I don't mean why could he have. I understand you have arguments why the district court could have, but based on the district court's opinion and order, what am I supposed to conclude about why the district court dismissed the 1981 claim?
I think that's a great question, Your Honor.
Doesn't that just answer the jurisdiction? Like, so then the next question is, why doesn't that mean we lack appellate jurisdiction? I have no idea why the district court dismissed the 1981 claim.
It is our position that yes, appellate jurisdiction is lacking here for exactly that reason. Walgreens moved to dismiss the complaint.
Well, if the district court got something wrong, and that's if, because that's not really before us, getting it wrong doesn't stop our jurisdiction, does it?
No, of course not,
Because
Your
it
Honor.
said, but based upon how I have ruled, it is moot and it's dismissed and the case was dismissed. If it's wrong, that doesn't shorten our hand as to jurisdiction. Matter of fact, most appellates will say that's what we're here for, to correct error, right?
I would agree with that, Your Honor. I think the distinction here is that it's not that the district court got it wrong on the 1981 claim, it's that the district court did not address that claim at all. And that claim was.
It did, it said it's moot. That is addressing it.
Did the court actually say the 1980? I was so confused about this mootness, by the way. Does the court say the 1981 claim is moot, or is it to say, given what I've already said, the other motions are moot?
So what the district court said is that the motion is granted as to 12B1, which
Right.
is the 90-day rule argument that we made as to the ADA and the Title VII claim. We also brought a 12B6 motion for failure
So
to
the
state a
12B6
claim.
motion is moot because I've dismissed based on 12B1?
Precisely, but we never argued that the 1981 claim was subject to dismissal under 12B1.
And just while we're there, it's the exhaustion requirement's not jurisdictional, right? Because the Supreme Court has said it and we've said it.
I would concede that, Your Honor, yes. Although it is our view that the result is the same whether the motion was.
Sure, but in your brief you say like courts are split. But so then I went down and I looked, and no, the Supreme Court has said it clearly in a footnote, and we've said it very clearly in Allen versus Atlas Box and at least one other place. Like, right? It's not unclear. The Supreme Court and this one have both said it's not jurisdictional.
I would not dispute that, Your Honor. I think perhaps it would have been better to bring it under 12B6, the entire motion.
What should we do with this section 1981 claim? Send it back?
Well, Your Honor, I
Or-
think
Or if we don't have jurisdiction, just let the district court go forward?
I think that's correct, Your Honor. If this court decides that it does not have jurisdiction, then the 1981 claim should be remanded for consideration under our 12B6 motion.
What's the
If-
alternative? Don't we just send it back anyway? I mean, he didn't address it. It looks like he folded it in with the other two claims. He couldn't do that. You heard the counsel correctly state it's not subject to the 90-day rule.
That is correct, Your Honor. With that said, if this court does conclude that it possesses appellate jurisdiction, it is, of course, empowered to affirm on any basis.
I'm
in the
not making an
record.
argument. You keep using if. I'm saying, why don't you just say the court should just remand it and move to another argument?
Right, well, that is our primary position,
thank
Your
you.
Honor. But I would say secondarily, if the court determines that it does have jurisdiction, then it is empowered to affirm on any basis of the
Again,
record, and we think it's clear that
I
the
go back to
complaint
this
fails.
jurisdiction. Jurisdiction is very important. Obviously, we're Article III judges, or Article III court. But again, getting it wrong does not change jurisdiction. We have many cases where we find that the district court did something error, but the jurisdiction, we used it and we said it needs to be remanded. Something left to be done does not necessarily implicate jurisdiction, because what he said was that based on my rulings, that the rest of it is moot. Now, my dear colleagues, we don't know, we don't side cases in front of the audience, so we'll do that later. But the point is that, why does that change jurisdiction? The power to look at the case, is it terminal because it was an error that clearly there was no exhaustion required and that kind of thing, whatever? But that's what he did. He ended the case and said, because based on this ruling, this is moot. And that's what we do a lot of times. We said, no, it needs to be remanded, because we don't say we don't have jurisdiction because, well, we don't have power to look at this case now because he erred this way. I said if he did, because we haven't decided that yet, really. That's not before us. Jurisdiction is before us. It's whether or not it's finality, not whether it's right or wrong. So tell me, why is that? Aren't we turning it on upside down here in terms of, why don't we have jurisdiction, power?
So, Your Honor, I think that the issue here is that the district court, not that it got it wrong necessarily on the 1981 claim, is that it didn't acknowledge the 1981 claim at all. And in fact, the order denied as moot to the extent predicated on 12b-6, which was the only basis that Walgreens argued for dismissal of the 1981 claim.
Did it say that? Tell exactly what the court said.
I have it
What,
on the
Oh, I thought you had that
table over
front
there,
and,
but
thought you had that front and center. Go ahead.
sure, I'll grab it.
Quote it. It's only a small print.
Apologize, I should
No,
have
no,
brought
no,
the
apologize,
binder up
no
to
problem.
begin with.
No problem.
So we're looking at JA 180, I
Yeah,
think.
just read it.
Yeah, so the order reads, it is ordered, adjudged, and decreed that plaintiff's motion for leave to file on paper is granted. Defendant's motion to dismiss pursuant to Federal Rule of Civil Procedure 12b-1 is granted. The remaining portions of that motion are denied as moot. The case is closed.
Okay. Now, that motion, how do you say that includes the 12b-6? You said includes that, or did not?
It did not include.
Didn't include that. So we got, they didn't include that at all?
I'm sorry, Your Honor, the order.
It didn't, the order didn't include, what else did it include? Something else, didn't it?
That was the, well, I'm sorry, it says the remaining portions of that motion are denied as moot. The only remaining portion of the motion was the portion brought pursuant to 12b-6.
Of that motion?
Correct, of defendant's motion to dismiss.
And then it just, didn't it dismiss the whole case?
That is correct, Your Honor.
Right.
Yeah.
So what was that, what was the court doing there? Ending the case, I'm finished with it. Isn't that normally what that means?
Yes, Your Honor, but we think that under this court's precedents, and in particular under Porter, when a court fails to address an independent claim for relief, yet nevertheless purports to close the case, Porter tells us we have to look to the substance of the order rather than its form. And it's our view here that looking at the substance of this order, it is clear that the court has not adjudicated the Section 1981 claim. And as a result, we don't believe that there's appellate jurisdiction here. I'm happy to answer anything further on the jurisdictional question, and otherwise I'm happy to move on. So I was planning to address the request for jurisdictional discovery before the Eastern District of Pennsylvania, but it sounds as though that is
Haven't we
not
said we don't have appellate jurisdiction to review decisions of the court before it transfers?
Yes, Your Honor. I don't think that there's really much to be made of that argument, so I'm happy to move past it if that's agreeable. So now moving to the 90-day rule and the ADA and Title VII claims. Walgreens argued for dismissal of those claims on the basis that they were untimely. That's because to be timely, the statute requires a plaintiff to file the lawsuit within 90 days of receipt of the notice of right to sue from the EEOC.
That's not jurisdictional,
Uh,
the 90-day rule. You agree to that?
Correct, Your Honor. That is more in the nature of a statute of limitations defense.
And we've also said it's an affirmative defense, right?
Yes, Your Honor.
Haven't we also said you can't decide affirmative defenses on a 12b6?
Well, Your Honor, I think it's a
I
little
mean,
bit.
well, sorry, let me rephrase. You can't decide affirmative defenses on a 12b6 unless the complaint or a document integral to the complaint establishes the affirmative defense as a matter of law.
Yes, Your Honor, and we believe that's exactly what the situation
What
is here.
document that's integral to the complaint establishes as a matter of law the affirmative defense?
So the notice of right to sue, which.
How is that, is that quoted in the complaint?
There is an allegation in the complaint that the complaint was timely filed within 90
Okay,
days.
but there's
of
nothing in
receipt
the, there's nothing in the complaint about when the right to sue letter was received, right?
of- No, Your Honor, but
Was the right to sue letter attached to the complaint?
it was not, Your Honor.
So why is it integral to the complaint?
Well, it's our view, Your Honor, that because the complaint includes an allegation.
That it's timely?
That the complaint was filed within 90 days of receipt of the notice of right
So that
to
means
sue.
we can go outside the four corners of the complaint to figure out whether that assertion is true?
That would be our position, yes, Your
Wait,
Honor.
but that's, I mean, that would really do some real violence to Rule 12b6, right? Because I presume there are lots of things in complaints that defendants think are not in fact true. Complaints allege things all the time the defendants think are false.
Right, Your Honor, but I think, our view here is that because the complaint made a specific reference to the notice of right to sue, and the notice of right to sue bears that mailing date of September 20th, in applying the 3-day presumption, the document controls
Hold
over
on,
the
but I'm just thinking through
allegation.
I'm thinking through the implications of that, and they're sort of breathtaking. The complaint, for example, says, during a meeting, my supervisor used a epithet to refer to me, and then the defendant says, motion to dismiss, here's a recording of that meeting, and as the recording will show, the epithet was never used. You could never consider that on 12b6, right?
Well, I think that's an interesting question, Your Honor. I think that,
Really? You think that's interesting, or you think it's obvious that you can't do that?
well, I think that there's a distinction between a written document and a recording, which is subject to questions of authenticity.
I would think that a recording is subject to fewer questions of authenticity. I can literally listen to it and hear what someone says. If you have a document, someone say, that might not be the document, or there's a later document, or I got another letter, and the other letter had a different date on it. I mean, really?
Well, Your Honor, I think that, again, it's our view that it was incorporated into the complaint, and the document speaks for itself.
What's your
as
best
to the date
authority
of
for the,
mailing.
okay, so let me ask you this. What is your best authority for the proposition that just because the complaint alleges that the suit was timely, which it seems to me the complaint probably needs to allege, or at least I suspect the vast majority of employment discrimination complaints do in fact allege, what's your best authority for the proposition that that incorporates the right to sue letter into the complaint?
Your Honor, I'm happy to pull a citation for you here.
Great, thank you.
So we cited in our papers the Bratcher case, which is at 545 F sub second 533.
So F sup, that is a district court case, right?
That's correct, Your Honor.
You have nothing from the Supreme Court or this court that says that?
Not as I stand here today, Your Honor, but I would be more than happy to submit supplemental briefing on that question if the court would like that.
Well, the Goodman case that your counsel on the other side brought up, I mean, that's a case you ought to look at, I mean, because this is very critical. And it almost goes to the same question I asked. How do you just say 90 days, I met it, and that's enough? Well, it goes for you too. How do you just say, okay, it's not met, and then you incorporate something, it incorporates something that goes along with you saying that? The Goodman case says, basically, in rare instances, if those facts are alleged in the complaint, then you can proceed with it, with affirmative defense.
Right, Your Honor. So it would be our view that once a document is incorporated into the complaint, which, again, I understand your concerns there, Your Honor, it is essentially alleged as part of the complaint. It's integral to and therefore incorporated into the complaint. And so
That's the problem we got. This is essentially alleged and, it incorporated in terms of that. So it really gets tenuous. It's a rare instance it's going to be done in the first instance. The question is, it's done, are the facts alleged in there to establish it? And when you get on this level and you start saying, well, you get to look at this, and, after you bring it in, there's still the question of, a lot of smoke being brought about, a whole lot of dates all over that document. And, you know, maybe the handwritten notes don't trump the actual the date, the signature or the certification, so the court called the certification meets, but there's a lot of stuff there. So why should we make this one of those rare instances?
Right, Your Honor. So I would just point out that the copy of the notice of right to sue that was attached to our motion was Walgreens' copy. And as counsel for the EEOC noted, that handwritten notation there was made by an employee of Walgreens. The plaintiff below has not come forward with her copy of the notice of right to sue, a postmarked envelope, or even an allegation as to the date of receipt. But instead, what she did allege is that the complaint was timely filed. The document shows, in our view, that is not true, and the document controls over the allegation when a document that is integral to, incorporated into a complaint, is contradictory to the written allegation of the complaint itself. So I'm happy to answer any further questions on the 90-day rule issue. But otherwise, I would just touch briefly on the Section 1981 claim, if in fact the court concludes that it possesses jurisdiction here. And on that point, it's the case that this court can affirm on any basis in the record, even if the reasoning of the district court differed. Here, it's our view that the appellant has not stated a claim for race discrimination under Title VII or Section 1981, because those two claims rely on a common set of facts. In essence, the allegations relevant to race discrimination boil down to, one, the allegation that she was subjected to race discrimination, two, the allegation that she was treated, quote, different and worse than non-black coworkers, and three, that she was terminated due to race discrimination.
All of this you're asking us to do, district court has not done, or
That-
did not do.
That's correct, Your Honor, but I believe that
You
this
heard
court.
Judge Gregory says, are we here to do the district court's job, or should we do it when we have an audience like this and we're just off the top of our head looking at the record, or should we just send it back?
Well, Your Honor, I think that's a fair point, but I guess what I would say is that the district court would be looking at the same record as this court, that is the complaint, and it seems to us that this complaint does not state a claim for race discrimination, and that is obvious on the face of it. So given that is a document that's, of course, in the record, that provides an avenue for this court to affirm.
So you argue judicial economy.
Yes, Your Honor. This is a case that was originally filed in 2019. The Eastern District of Pennsylvania transferred venue in 2020, and for whatever reason, nothing happened for 2 years. The case was never opened in North Carolina. So it's our view that, you know, this case has been kicking around long enough, and there's no reason to go back to the district court if the record as presented to this court would support affirming the dismissal of that claim.
Just want to go back to, just to be clear, make sure, because you don't get a chance to come back, and I don't want to ask counsel, and you don't get a chance to have a retort. But you filed a motion to dismiss, didn't it include the 1981 issue as well? That it didn't, you said that they didn't state a claim, right?
That's correct, Your Honor. We moved pursuant to 12b-6,
Right.
arguing that the 1981 claim fails under Twombly and Iqbal.
Right. And so you're saying that when the court was solely looking at just the, not, they weren't there with the whole motion to dismiss, when it said that to the extent the other portions are moot? Because wasn't the court looking at the whole thing? You said that you're pleading that they failed to state Section 1981 action, didn't you? And you said, it's right? That was in part of your papers to the court.
It was, Your Honor.
So that was before the court, correct? And it said, to the extent all the other portions are, right, dismissed. I mean, they're moot, because I've knocked it out because it's not across the board. There's no stating of a claim, period. So why are you limited to say, oh, no, that was just this, but not that? Wouldn't it cover everything? I'm getting to in terms of, Everybody said it was a mistake or wrong, but the court said the rest of it is moot. And for the plaintiff now is to come to this court for appellate relief. It's not about whether that was right or wrong. We could pick through that. That's not before us. But you said that it failed to state a claim across the board, period. And that's what the court said. I'm gonna deal with this one right here, but to the extent the other portions of portions, which included your claim, I don't need to deal with that because you did put that in play. So I don't understand why you'd say that. Can you answer that question?
Of course, Your Honor. So the 12B1 portion of the motion, which is the portion that was granted by the district court, was addressed only to the Title VII and the ADA claim. It was not addressed in any way at the 1981 claim. The court granted Walgreen's motion only to the extent it was brought pursuant to 12B1, but there was no argument that the 1981 claim was subject to dismissal under 12B1. So in denying the remainder of the motion as moot, that is the portion brought pursuant to 12B6, which was aimed at the 1981 claim, we don't believe that the court has actually adjudicated that claim, which is why it's our position that there's no appellate jurisdiction here.
So under this record, then, there's no way the court could have thought that it did cover broadly your motion to dismiss, included those.
Based on my reading of the order, Your Honor, I don't see that. But again, if
And he did close the whole case out,
that is correct, Your
which would be consistent with the interpretation I'm talking about, right?
Honor. I suppose it would, yes, Your Honor.
Yeah, so why should our jurisdiction hinge on your interpretation of it when the court clearly dismissed the case and was dealing with your across-the-board motions as you said that it failed to state a claim, period. That's what you said.
Well, Your
And it's
Honor,
failed to state a claim under Title VII or Section 1981. That's what you're arguing with the court the whole time. The court saw these papers and said, look, I don't need to deal with the rest of it based on this. It's finished. It's done. Isn't that the time to come to the appellate court?
and I'm over time here, so
I'm talking to you, so you're okay.
Okay, thank you, Your Honor. So we did not argue that the ADA claim, for example, fails to state a claim. We argued that the Title VII claim and the 1981 claim did fail to state a
Right.
claim, but that the Title VII claim was subject to dismissal for two reasons. One, because it was not filed within 90 days, and two, because it failed to state a claim. The court granted the motion only, as far as we read it, only as to that first argument on the 90-day rule issue.
So if a court has properly enters an order insofar as those two claims, but not the other one, what indicates that that's not functionally flawed? And in other words, we don't take piecemeal type appeals. We typically send it back and says, get the whole thing. We don't take, you got part of it right, other parts you didn't get right. Because there's got to be a final judgment.
I completely agree, Your Honor.
So
and
it's not a final judgment on Section 1981.
I totally agree, Your Honor. That is
We
our
don't
view.
take appeals from things that are not final judgments, so why would we take part of the appeal? This is not a qualified immunity case or something like that where you got a basis for doing so. And if we start this, then where does it end?
Right, Your Honor, and that's why it's our view.
You'll come back up inside a case, says you did in this case here, and you need to do it again.
Right, Your Honor. So again, it is our view that the case should go back to the district court simply because there is no jurisdiction here. I mean, it would be great to have it resolved for the considerations of judicial economy that Your Honor raised earlier, but considerations of judicial economy cannot sort of supersede the requirement of appellate jurisdiction.
Okay.
All right.
Okay, thank you.
Thank you, Mr. O'Halloran. Mr. Vance, you have a little time left.
3 minutes, I think, Your Honor. So I want to address a couple points that Judge Wynn wrote.
Would you be okay with sending the whole case back to the district court at this point?
Yes, I would, as long as the order that sends the case back instructs the district court to allow the parties to take discovery on the 90-day issue.
Wait, how can a court conclude it lacks appellate jurisdiction and then give some gratuitous advice to the district court of what it's supposed to do on remand?
Well,
Doesn't lacking appellate jurisdiction mean you lack appellate jurisdiction?
Right, but that's not what I'm saying. I'm not saying send it back because you lack appellate
Sorry,
jurisdiction.
thank you, I misinterpreted you.
Yeah, I'm saying send it back because it should be sent back, so that the Section 1981 claim is addressed, and it should be sent back on the issue of the 90-day requirement. Because I think, as Judge Wynn pointed out, in the complaint, I allege that the plaintiff filed the complaint within 90 days of receipt of the notice of right to sue. The defendant answered the complaint, denied that, asserted the affirmative defense of the statute of limitations.
And the defendant has the burden on the affirmative
That's
defense.
absolutely correct. And as long as I've been practicing law, once these issues are joined, the way that they are resolved is you take discovery and resolve the issue, which is our point from the very beginning, which is that the district court, if the defense claims that the 90-day requirement was violated, then prove it. Let us take discovery, depose Ms. Weaver. Let's depose the counsel for Walgreens who wrote a notation on the document. Depose the relevant people from the district office of the EEOC on that particular issue, on that limited issue of the 90-day requirement, if that's what the district court wants to do. But you cannot simply take an allegation made by the plaintiff in a complaint and on a 12B1 motion to dismiss, which is entitled to be accepted as true, and basically say it's not true, based on evidence, or quote-unquote evidence, that the defense presents that the plaintiff has no opportunity to contest under the normal rules of how we proceed in district court. So that's the only point I wanted to make on rebuttal, is that the issue, at least for the plaintiff, is clear. The district court's error was in not allowing the parties to take discovery on the issue of the 90-day requirement. And this court does have jurisdiction because, as Judge Gregory pointed out, the judgment, which we're talking about, not the order that accompanied the judgment, but the judgment is crystal clear when it says this case is closed, and hence we're here. Thank you.
Thank you.
Thank you.
Mr. Vance, our counsel. We'll come down and greet counsel and proceed to our next case. Ms. Baldwin, when you're ready.
Good morning, Your Honors. May it please the Court. Melissa Baldwin on behalf of the appellant, Mr. Ramirez-Avila. We are asking this Court to vacate Mr. Avila's sentence as procedurally unreasonable because the District Court erred in finding 2G 2.2's cross-reference was satisfied by the defendant offering money for specific conduct. Section 2G 2.2 lists 4 circumstances that trigger the cross-reference: causing, transporting, permitting, or offering, or seeking by notice or advertisement. None of these circumstances are met by a defendant offering money for specific conduct.
May I ask you a question about a procedural issue in this case? So it's tricky because, of course, the PSR is sealed, and I understand why that is. It strikes me that the critical paragraph in the PSR is paragraph 20 on page 219 of the sealed JA. Sorry, paragraph 20 on page 219. And again, I know it's sealed, so I'm going to not quote it. But when you find it, could you go to the second to last sentence of paragraph 20?
Oh, sure, Your Honor. And
Okay, no, well, sorry,
This is the summary of the minor's interview with the FBI
Okay.
agent.
And I'm now looking, this is just so we're clear we're all talking about. I'm looking at JA 147 where you object to the PSR.
Correct?
Okay, and I see paragraphs 15 through 20. And I read that sentence, and I'm not going to read it out loud, but the sentence you say, the evidence indicates some things. Let's posit for the sake of argument that sentence that you say is true, right? I don't see how that sentence actually takes issue with the truth of the second to last statement in paragraph 20, right? You say, when it's more in the nature of, there's some additional facts that the court might like to know, but I don't see you saying, we object that the penultimate sentence of paragraph 20 is not true. Is that
So
right?
I'd agree with that, but I disagree with the notion that it's a penultimate statement or
No,
that
I'm just trying to do it because it's sealed. I mean the second to last sentence. I'm just trying to direct your attention to the sentence.
No,
I'm
no,
asking.
I understand. So the
Okay, and
sentence-
so the sentence here is recounting something that a victim said to someone, right?
Correct.
Okay, and said, and this I've checked is quoted in unsealed parts of the record, said that he made and sent. That is quoted in unsealed portions of the briefs. And you didn't object to the factual truthfulness of the statement that the victim told the person who interviewed the victim that he made and sent, right? You didn't object to the truthfulness of that representation, did you?
Correct, but I don't think that statement supports the cross-reference in and of itself,
Okay, so let me ask
especially
you
in the context.
one question. So you could be doing two things. You could be saying that statement is not true, or you could be challenging the implications of that statement. For purposes of
Because I think it assumes facts that aren't contained in that statement and are disproven by other facts in the record. So for example, if I say I made a painting and I made the painting on Monday and hey, John Doe offered me $20 on Tuesday and I sent it to him, that would be correct in saying I both made the painting and provided it when offered $20, but it doesn't show that I painted that painting before the offer was even made. And so that's the
well,
problem.
hold on. Conceivably it does, but now I'm going to have to, I don't know how to ask this question without going a little farther in the sentence. It says made and sent these requested videos. Doesn't made and sent these requested videos very strongly imply that the making was after the request was made? Like,
Again,
as a matter
I
of
disagree.
normal.
This is not a direct quote from that interview. It is a summarization. And again, I think that's inserting facts that are not only not in the record, but the evidence shows that it actually is more likely not to be the case.
So
in
why
the
don't
sense-
your objections say literally any of the words you just said?
I mean, I construe the objections as saying that. I mean, we point to the specific paragraphs we take issue with and point to additional evidence to rebut any suggestion or implication that those paragraphs might have at the notion Mr. Avila caused the creation of the video.
Well, but this is the part where I actually am very empathetic to the district court's seeming confusion, because when I read this, the sentencing transcript was just to make, the sentencing transcript was not sealed, right?
Correct.
Okay, so the district court at the sentencing transcript says, you're saying, and the court says this on the record, I'm pretty sure, you're saying this victim made and sent other videos to other people, and the district court, I genuinely think the district court was confused, because the district court judge says, like, I don't understand why that's relevant. The fact that there were other victims of other crimes doesn't have anything to do with whether your client committed this crime in this way. Because there were parts of the argument I think the district court interpreted as like, the victim was asking for it because he was doing this with other people. And the district court says, with all due respect, that's not a defense.
No, we're not saying that's not a defense, but the government offered two, bases for this cross-reference. And one, that was Mr. Avila caused the creation of the videos,
Sure.
which directly goes to the idea, if these minors were creating other videos, as we know they were for money, then there is a causation problem here and there's a proof problem here. And the fact the government itself acknowledged that because it said, hey, listen, we get it. If the district court, finds we presented insufficient evidence to prove causation, you should still apply the cross-reference because we think an attempt to violate 2251A satisfies the cross-reference. So the fact the government itself is acknowledging, our evidence might not be as close as it says. And even the government's response on appeal, they don't make any effort to contextualize the other evidence. They point specifically, again, to paragraphs in the PSR that were never, explicitly adopted by the district court to suggest and draw this implication.
Wait, what do you mean not explicitly adopted? Didn't the district court say, I adopt the PSR?
Well, I believe the court said it was adopting the guidelines calculations in the PSR.
And so you're,
Well, I mean, the guidelines calculations is different from like the factual paragraphs that we.
well, actually, on that front, then can I, well, if we're gonna talk about what people said at the sentencing hearing, what do I do with the fact that Avia's counsel at the sentencing hearing said, to the extent I have objections, they don't impact the guidelines range? Because now it sounds like you're trying to assert that these objections do infect the guidelines range. This is at JA 28. At the sentencing hearing, I understand counsel to have said that the objections to the PSR's statement of relevant conduct do not affect the guidelines range.
Well, in the sense that, well, I don't think it matters, right? Because we're saying.
Really? What? But this whole argument is about the guidelines range.
No. I mean, I'm sorry. I don't think it matters in the sense whether or not a particular paragraph was adopted, because that I explained.
No, I'm not asking about the adopted. I'm sorry, I pivoted to a different question. What do I do with the fact that at the sentencing hearing, defense counsel said, yes, we have some objections to the PSR. Those objections, I think this is a quote, the objections to the PSR, statement of relevant conduct, do not, quote, impact the guidelines range.
Well, I don't think that's a fair interpretation of the reading, because defense counsel goes on for another 6 pages to argue why the cross-reference doesn't apply.
So, so it'd be the range before the cross-reference. So that's how we should put. Okay.
So here there was no finding by the district court that any minor created the videos at D's direction. So that knocks out the causing aspect of the cross-reference for circumstances. There's no suggestion there was any transporting. Permitting here, although the government has argued it qualifies, I think it's pretty clear it doesn't based on the canon of consistent usage, because here it's cross-referencing to a guideline that's specific to custodial authority over the minor, as well as the statute itself, 2251B, limits, criminal liability for this permissive action to ones with custodial authority. And then going on to the not offering or seeking by notice or advertisement. Now here we're asking this court to agree with the 11th Circuit's decision in Caniff, that the by notice or advertisement provision excludes private one-on-one communications like those Mr. Avia engaged in here. And we think 3 statutory principles support this construction. First, under the canon that a term should be known by the company it keeps, notice should take on a public connotation given its presence alongside advertisement. Second, the rule against surplusage prevents this court from reading notice to its broadest possible extent of simply conveying any information.
So I got the notice in the advertisement connection you're making, but the government is relying on the causing prong, not the notice in advertisement.
Correct. So, I mean, our position is the cross-reference doesn't apply because the court's ruling's wrong. It doesn't fit into any of the 4 circumstances.
I got that, but they only,
Yeah.
I think you can focus on that causing one.
Okay. I mean, we did argue and point out that the government has waived that argument, so I'm happy to leave it at that. But that said, we do think the 11th Circuit got it right, and notice or advertisements should exclude private one-on-one communication. But again, at creation, and something I want to point out that probably wasn't clear in the briefs, but I think is pretty, telling as to what happened in this case. Now, if you look at paragraph 32 at JA 136, that's the initial draft PSR in this case, when the probation officer said the cross-reference, applies here, and quote, because the offense involved causing a minor to engage in sexually explicit conduct, right? And so then the defense objected, submitted our additional evidence showing like, hey, we have other evidence showing that these minors, were creating these videos and distributing to other people. And as well as, some of the text communications present a real suggestion that these minors, the videos Mr. Avila received were created before the communications in that case. So after those objections came out, what the final PSR did was it took out that causation finding in the initial PSR and said, paragraph 37 at JA 222 said, a cross-reference, quote, must be evaluated, and then simply quotes the language of the cross-reference. So, and that's why the government's reliance on the statement of reasons adopting the PSR, subject to its rulings at the sentencing, doesn't help the government here, because the PSR...
When did the court adopt that PSR? Was it during the sentencing hearing or after?
So, my position is the district court adopted the guidelines calculation from the PSR and then adopted the PSR findings beyond the guidelines calculation after sentencing in the statement of reasons.
Because he definitely did that, right? JA 220, the district court checks a box that says, I adopt the PSR subject to the following changes.
Yeah, absolutely.
Which would include the factual parts of the PSR.
Right. I think, again, it doesn't really, we've talked about it, and I don't think it determines it, but, the ruling is it's the oral pronouncement at sentencing. This is Rogers and stuff. It's the sentence is what the district court says at sentencing. Right.
That would be a further extension to say the district court can't adopt findings in its written order.
Well, no, but I think 18 U.S.C. 3553C, which requires an on-the-record explanation for sentencing, would kind of implicate that. So going back to the causation, so here, the fact that the court's finding itself, if you look at JA 40, says nothing about causation. In fact, it says the offering of money for specific conduct. So it is that precursor step to any creation. And, that offering money for specific conduct does not equal causation, right? If I go to an artist booth at a craft fair and pay $20 for a cat picture, that in no way establishes if that cat picture was made as I was standing there or if it was made before the fact. And so based on that, we think the cross-reference here was erroneously applied, and I guess I'll just quickly address the question of review because the government has posited that this should be reviewed for clear error. We disagree with that. This is subject to de novo review. It's a legal question as to whether or not the court's finding offering money for specific conduct falls outside or inside the boundaries. We have no dispute. We agree.
So that's a dispute, because that's a dispute about what the guideline means, right? That whether offering money for specific conduct without more, whether that satisfies the guideline, that is a legal question.
Right, correct, Your Honor. So we absolutely agree that Mr. Avila offered money for specific conduct. The question is whether or not that finding can support the cross-reference. And, as we laid out, it doesn't fall into any of the four circumstances enumerated. Therefore, it was error for the district court to apply that cross-reference. And as a result, we're asking this court to vacate the sentence and send it back for resentencing with instructions not to apply the cross-reference.
Wait, why would that be the remedy? The remedy is the district court didn't do a good enough job explaining why it did. The remedy is to instruct it that it can't do it. Why isn't the remedy to say, do it again, do it right?
Well, because the finding the district court made doesn't support the cross-reference. And so I think, there's no reason to send it back and wholesale do it over again.
Hold on, but you said we don't need to reach the by announcement because the government has waived it on appeal, but if we send it back for resentencing, the government has not waived it before resentencing, right? Let's say hypothetically one were to be inclined to be of the view, you've cited the 11th Circuit's decision, but of course there is a circuit split on that precise question, and the 6th Circuit has an opinion saying, with all respect to the 11th Circuit, we think you're totally wrong about that. And we haven't answered that question, right?
Correct, Your Honor. And so, I can't give you an authority saying, you cannot send it back for, further reconsideration.
Isn't, in fact, doesn't that seem important? Because isn't the normal remedy for a procedural sentencing error to say, try again? That is the remedy we impose for procedural sentencing errors.
No, not necessarily. I mean, if the legal error is the cross-reference applies because of X, but it doesn't, I don't see why that then opens the can of worms to, reevaluate it.
Really? I just feels like we vacate district court decisions all the time and says the reason that you did what you did is not valid. Consider again whether you can do the same thing for a different reason. That is routine in appellate review all the time.
Right.
Not you can't do what you did.
Right, I see my time has elapsed. May I just answer the
may.
question? So I agree that this court does that all the time. I would say this court also all the time has cases where it says the government doesn't get a second bite at the apple, right? They have had their opportunity, they presented their evidence. It wasn't enough evidence to show causation, given the unique facts of this case, and so in line with that, that's our requested remedy. Thank you, Your Honor.
Thank you, Ms. Baldwin. Mr. Enright?
Thank you, Your Honor. May it please the court. Anthony Enright for the United States. The district court properly applied the child pornography production cross-reference because Avia caused a 15-year-old boy to make and send sexually explicit videos of himself with his offer for and ultimately payment.
So, Mr. Enright, can I ask your friend on the other side what I viewed as the problem for them? Let me identify what I think is the big problem for you.
Certainly, Your Honor.
I'm looking at JA-40, and that is not what the district court said. The district court said, I'm going to overrule the objection, that doesn't really add anything. He then quotes the guidelines, fine, and then he says, this is on JA-40 transitioning to 2040. So there's this whole debate, did he cause it, did he not? No matter else we can say, the parties at the sentencing hearing are disagreeing at the sentencing hearing.
Yes.
And I read why the district court does what he does, and he doesn't say, I agree with the government that he made these videos in response to the defendant's request. He sort of quotes it sounds like the original draft PSR and maybe the language of the commentary, and I think the most natural interpretation of what the district court says is, I don't have to resolve that, because really the only sentence the court gives to explain why it's doing what it's doing. This is the conduct involved in the factual basis, that there is money offered for specific conduct that meets the elements of the cross-reference. That is the sum total of what the district court says. And it sounds to me like what the district court is saying is, offering money for conduct is enough, doesn't matter if the videos were made in response to this defendant's request. And that strikes me as different than saying, I find, as a matter of fact, these videos were in fact made in response.
So I have a few responses to that. I think the first is that I disagree with that interpretation of the language, because first, the court does quote verbatim the entire standard and then says, it does appear to the court that this, presumably the referent is the whole standard, is exactly the offense conduct involved in the factual basis. And then second, he says that there was money offered not for specific conduct, the end, but specific conduct that meets the elements of the cross-reference.
So the idea is that
causation's one of those elements. I'm sorry, I didn't mean to.
No, please, I'm sorry. We can all agree it would have been better if the district court had just said the words, I find the videos were made in response to the defendant's request. We all agree we'd have a much easier case if the court had said that?
Absolutely, Your Honor. But there's a rule for how this court scrutinizes the district court in United States versus Gross. It didn't make it up there, but most recently. You presume the court knows and applies the law. Unless it explicitly says, here's the standard, it deviates from what this court has said or what the standard is, and I'm applying that.
Well, but, okay.
This is an explanation.
Can I take a step back? So the question I asked your friend on the other side, you agree with me, there's a question. The question is as follows. Is this guideline satisfied simply by offering money in exchange for specific conduct without any showing of anything else? Is the guideline satisfied simply by that? Do you agree with me that the question of whether that satisfies this guideline is a legal question reviewed de novo?
That's probably correct, Your Honor.
Like whether that's a correct formulation of the law is a
Yes,
legal
the
question.
interpretation of the guideline, where its boundaries
And
sit.
do you further agree with me that it appears that among other things, the parties before the district court were disputing what the proper interpretation of the law was? With the government arguing, look, there's language in the government's filings, I think there's language in the draft PSR, there's honestly even some language in the guidelines commentary that suggests that mere solicitation is enough, that's all you need, right? There was atmospheric arguments being made about that, right?
I agree that that's in the commentary to an extent, but we argued pretty specifically, as did the other side, that this is about causing. Right before this, on page 40, what's our argument? By coercing and enticing with the money, he caused G. That's using the reference, talking about the guidelines.
No, I
saying those are ways of causing. Caused G to make the videos and send the videos to him. That was our argument.
But to answer Judge's question regarding the offering of the money, would that fit in the offering part of which you are not bringing to us?
That's true, Your Honor. I think if there's a fair argument that you can seek by notice to have somebody provide engage in sexually explicit conduct for the purpose of producing a visual depiction.
This is literally the Sixth Circuit's holding?
Yeah, the Sixth Circuit and the Ninth Circuit and the Seventh Circuit and the Tenth Circuit.
Sure.
But I didn't raise that argument. I'll be very candid about that. But
So you're not going to argue then today?
I'm not, Your Honor.
Okay.
I will happy to answer any questions this court may have about it, but that's not our argument. Our argument is that it was cause. Our argument below was that it was causation. And the court even clarified with the defense. The defense said, I think on page...
But the government did argue that other provision below. You didn't argue, I just want clarifying the record. The government at various points below, did it ever?
Not exactly. We argued that an attempt would satisfy the requirement, and I have not repeated that up
Okay,
here.
thank you.
And we did that in papers. And then in the district court, we told it was causation. And the court clarified, I'm trying to find, I wrote it down, but now my eyes are not letting me focus on this, unfortunately. But the defendant also had an exchange with the court where the court said, and so you're arguing that there wasn't causation here. He said, yes. That was the question before the court. Nobody argued a different interpretation of the guideline.
Okay, so go back to causation then. Can I ask you, is it possible to cause something that has already happened? Can Y cause X if X has already happened before Y?
Generally not, Your Honor.
Right. So factually, if as a factual matter, all of these videos existed before the defendant's request could not have caused them, right?
I think that's correct, Your Honor, but there's plenty of evidence.
No, I understand. But that's a separate question. That's a separate. But we agree that if
Yes, there's no cause if he sent a video that he made in the past in response to his request to make a video for me. But the fact that that was the request, that was the nature of the request, and he even expressed in the parts of the record my friend cited, which were our filings, not in the pre-sentence report, the victim even expressed physical pain at the kind of sexual act he was asked to engage in right then. And they even have a conversation about when they agree on what the conduct will be. He says, well, I should ask permission. Can I discuss sealed parts of the appendix? I believe I don't have an objection to that. But I want to make sure, because we have had a little bit of a back and forth on that.
Well, I mean, I don't think we ruled on that motion.
We did file a motion last week. I don't think we've seen a ruling, but that's why I want to just get the court's permission. I won't be gratuitous at all.
Well, I mean, I don't know, is for the nature just because of graphic language you want to use, or because of this issue here in terms of whether or not there was causation?
The only reason I ask is because this part was formally sealed. It's in the second volume of the joint appendix.
We know, as a court, we honor sealed documents that come up from the district court.
Yes, Your Honor.
And if you notice, Judge Hyten, this morning, he did the same thing in his question. He was very cautious to do so. And if we are, and I assume that you ought to think that you have to do so too, and therefore I don't think you would.
Absolutely, Your Honor. I'm not going to reveal the victims' names. I just want to reveal one piece of language the parties exchanged that I think sheds light on the answer to this court's question, which is what kind of evidence shows causation specifically, that this video was made in response to a request from the defendant. I don't have to, but I think it will help the court.
Could you tell me what paragraph you're referring to so that I can find the information you would like?
I am referring to
And let us read it.
page 155 of the joint appendix. It's the top grid, and it's the exchange that occurred at 22:20 and 22:21.
155?
155. Now, that's part of our brief, but my friend has relied on that part of our brief as evidence that it would be physically impossible for him to have made the video. They actually make an agreement that I think a reasonable finder of fact could say was, you're going to engage in this conduct right now. Then 3 minutes approximately pass, and the victim expresses pain associated with the kind of conduct he was asked to engage in. And then he sends the video, and he acknowledges the video, praises it, and asks him about, hey, next time would you maybe film it differently? That's evidence from which a reasonable trier of fact could find that he made the video and engaged in sexually explicit conduct in response to an offer for money,
But
and that Avila caused that conduct.
But just to identify where, this is an argument that the district court could have made that finding, which is separate from the question of whether the district court actually made that finding.
That's correct.
Okay.
This is the clear error standard.
Well, no. The question of whether a district court made a finding is not subject to clear error review.
I agree with that, Your Honor. But if this court agrees that the court made a sufficient
Yes,
finding.
sure. Then it's,
This establishes that it was not clearly erroneous.
Yeah.
But under Gross, Your Honor, this court doesn't require the court to set out, either recite the standard. Although the court did that. The court recited the standard and said this conduct meets that standard. He went beyond what this court requires. What Gross says is that the district court's presumed to know and apply the law. He has to give you a much better reason than I think he did in
but
this
is that true
case.
when the law is disputed?
I don't think there was any dispute about the law, Your
Well,
Honor.
okay, separate question. Again, two questions.
I'm sorry. Perhaps not.
It just
although-
seems weird that we would presume, I know you're saying this isn't this case, but it would seem to me bizarre to say that in a case where the parties are fighting over what the relevant legal standard is, we presume that the district court got the right answer, whatever the answer happens to be.
Yes, Your Honor. Well, it's not a conclusive presumption. I think that would be evidence that might overcome the presumption. There was a dispute about the standard. The court ruled for one versus the other. Sure. Presumably, the court ruled for one because that was something the court had to
Well,
do. But here there was
the reason I say it is, and I'm not sure it's the only one, but when I read what the district court, and no, at some point we're just talking about how we interpret what the district court judge said. I think, to me, the most natural way to read what the district court says at JA40 is, wow, that's a hard question. I don't need to resolve it because I find that soliciting is good enough, and we definitely have soliciting here. That's a hard question. Let's not get into it. There's disputes about what people are fighting about. But fortunately, courts do this all the time, and I'm sure I've done it too, which is like, wow, there's some really hard questions. But fortunately, I don't have to resolve them because I can just decide this case on another basis.
Your Honor, I guess what I'm missing is the language of, wow, this is hard, or I disagree with something. Since there wasn't a dispute about what cause means, and there wasn't a dispute, as I think your Honor's question reveals, there wasn't a dispute about what the quotes from the chats were, or a dispute about what the victim said to the FBI agents. What my friend argued below was, well, he engaged in this kind of conduct with other people, and he sent videos to other people. And the court addressed that and said, I don't really see how that affects it. But I understand it to be cause. I don't think it's appropriate to interpret the court as saying, I'm going to make this legal finding that nobody really joined, especially when he says, this conduct meets the elements of the cross-reference. Because it does. That's an accurate statement if he is going with the government.
What conduct did?
It says the conduct
It
that
said-
in the pre-sentence report, in the factual basis, the conduct in the factual basis. It does appear to this court that this is exactly the offense conduct involved in the factual basis, and it says that right after it recites the entire guideline, practically verbatim on page 40 of the joint appendix.
When the court said, I think it was read, part of it said, it doesn't matter that you made this for other people.
Yes, Your Honor.
Was that the court was saying that this is about solicitation, what you did? But the fact that he made it for someone else, for example, is important in this case, isn't it?
I don't think so, Your Honor.
But there's evidence that this was going on apart from, right?
I think it would matter if he had a library of child pornography that he was sending to people upon request. But here we have very explicit evidence, including the evidence we had just had a discussion about, that he made at least this one particular video.
Well, you mentioned that because there were two victims, but on
Two
appeal,
victims.
you pretty conspicuously drop one of the two victims. And at least, because with regard to that victim, it certainly seems like there is evidence in the record that may suggest this library account, which is like, that with regard to this other victim, that victim was maybe sending things that already existed.
Yeah, we're not arguing that Jay's conduct alone would establish.
Except before the district court, you were relying on Jay. You weren't just relying, like, on appeal, you're only relying on one of them, but before the district court, weren't you relying on both of them?
That may be correct. I may have missed something, but I think, Your Honor, we were focused with Jay on some of the other objections. So we talked about them together. But I think our main position, and we say it right on page 40, the G.
Oh, I agree. Right before the court rules,
G.
right before the court rules, the government's talking about G. I agree.
I'm honestly a little bit fuzzy on everything we said. It's possible we did say something like that.
But I certainly agree.
I'm
The
not
ending
pursuing it
of
on
the
appeal.
government's argument is all about G. I'm looking at page
Yes,
40.
yes. I mean, I'm making that point here today. G supports that. I think there's a February conversation that's very similar. They discuss making specific videos and engaging in very specific conduct. He says, I'm not going to do this. I'll do that. Okay, well, that's good. That's not one of the charged ones, but it's certainly relevant conduct. It's in preparation. It's part of the same course of conduct. But I think the strongest is that April 22nd conversation where they talk about making. And that is enough for a reasonable fact finder to find, well, he didn't just pull from a library of pre-made videos.
Okay, so now you've drawn my attention to what the government says right before the district court ruled, and it doesn't strike me as that it helps you. Because the government in the penultimate paragraph right before the district court rules, this is the government's rebuttal, this is the instant before the district court rules, I think the word cause can include pretty much every one of the verbs that's included in 1221 and 51. I think that's just dead wrong as a matter of statutory interpretation. So if the defendant caused them to make the child pornography, I'm not sure what that means, and send it by enticing them, coercing them, persuading them, and then I look at this paragraph about G, and it says, again, the defendant, the chats are clear that this defendant wanted videos of certain conduct and offered to pay and did pay G for the videos. That doesn't prove that, none of that is saying the evidence shows that G made the videos in response to that request. None of that. And so the very last words the government says to the district court before the district court rules are, again, at least amenable to me to the interpretation, it doesn't matter whether the videos were made in response to the request.
Well, except we said by coercing and enticing you, he caused G to make and send the video.
But now we're just debating what cause means. And I agree, like, there's this language, well, I mean, candidly, I don't know if we have to get into it, but there's language, for example, in the commentary that said, isn't the word soliciting in the commentary? I think it is.
I have the book, but I don't remember. But it does say construe broadly. And what is in the commentary is a repeat of the main guideline language.
But then it adds a whole bunch of verbs that aren't in the main guidelines.
Yes, but, Your Honor, those all, I guess there's a statutory interpretation question. Can you seek, can you persuade, can you coerce if they don't do it? Just saying it. That's not what we were arguing at any point. Our argument was, maybe he sought, maybe he coerced, maybe he cajoled, maybe he enticed, maybe he did this, but ultimately he caused it because whatever verb you use, it convinced him to make the video. Convinced him to make the video. That's the key word we use in our argument, I think, is make. It caused G to make the videos, which we said, I think, pretty clearly. I mean, I suppose, Your Honor, Your Honor's Your Honor, but I would be very surprised if anyone in our office thought we weren't making that point, especially in the light of what I think was the strength of the evidence here. I do want to address the point about the objections. I think we talked about it enough, but I want to emphasize at the end of the sentencing hearing, I think we made clear to the court that the victims had decided not to be too cooperative with us. We obviously could have, if we wanted to, force the victims to appear and, using the compulsory process, but they are victims. We generally don't do that. We're here, there's no dispute about what they said. That's not something we would have been likely to do. So there's a good reason why we relied on the fact that the defense didn't say, no, this account of the exchange doesn't accurately capture what was said. So I think, and the court did on page 250, adopt the pre-sentence report subject to only saying I overruled the objections. So the court made that finding. And then it's in the pre-sentence report where the court says, where the probation officer concluded he engaged in conduct that met the standard. So I think the finding was made. This court could obviously, we could obviously disagree about what it is, but I think, especially in light of Gross, this court can determine that the court made a finding that it can affirm. If this court disagrees, though, to another point you made, the remedy would be, if this court believes that the court applied the wrong standard or misinterpreted the guideline, the remedy would be to send it back so the district court could apply the guideline correctly or apply the correct standard. Unless this court finds there's a clear error, that the evidence doesn't support the finding, there would be no reason to take that authority away from the district court. So, I see my time is almost up. If the court has no further questions, I'll yield the rather paltry amount I have of time back to the court.
Thank you, Mr. Enright.
Thank you, Your Honor.
Ms. Baldwin, you have some rebuttal time.
Thank you, Your Honors. So I'll just start with, the commentary does not include the word solicitation. It does.
My bad.
Yeah, it does add verbiage from 2251, but 2251 prohibits substantive violations as well as attempts, and an attempted violation of 2251A would be, the guidelines would be calculated under 2X1.1, which, as it just so happens, would be Mr. Avila's guideline calculations without the cross-reference to the production guideline. That's not here because the government has not made the argument that it made in the district court below that an attempted creation of child pornography should qualify for the production cross-reference. And I think there is a pretty difficult and persuasive Stinson argument that the commentary note does not deserve controlling weight or deference because it broadens the guideline language itself, as well as I think there is a parroting problem. And now just going on to the standard of review here, gross does not help the government in this case. In fact, it helps us. Because what this court found in the Gross case was it rejected that there was any legal error. So what the court said was, if the district court applied the correct legal standard, then the finding that the enhancement applied is reviewed for clear error. And then it contrasted that case with the Lewis case, where the district court had applied a general rule of application to trigger a guidelines enhancement. And this court found that that general rule of application was legally erroneous, and that was reviewed for de novo review. And that is exactly what we have here, where the district court's finding that...
Well, but there was a dispute about legal error in Gross. I'm looking at 721, it's head notes 4 and 5. Gross further contends the district court did not apply the correct legal standard because it did not explicitly reference the guidelines commentary that sets up 3 categories of serious bodily injury. Gross tried to argue that was a legal error, right?
Right, but it was rejected, so I don't think there's...
Well, and we said because we're not going to assume the district court was unaware of the 3 categories just because the district court didn't reference the 3 categories.
Right, so but I'm saying I don't think, because... So here, if the court disagrees with us and thinks an offer of money for specific conduct satisfies the cross-reference, yeah, it's clearly erroneous, and so we did make an argument that it doesn't satisfy clearly erroneous, given all the contrary evidence in the record, which the district court's 1-paragraph ruling would not acknowledge and otherwise address, which is a basis to find a factual finding clearly erroneous under this court's Wooden decision. But, as I think Judge Heidens pointed out, the record doesn't support that the district court made that finding. If you read the district court's ruling at JA 40, the district court did not find causation. I think it went out of its way to not find causation and instead said, I'm doing the offering of money. And that doesn't satisfy. But even if there were some questions as to whether or not what the district court's findings were on that point, you don't assume a finding that was not made. At that point, I think the district court's fact finding was deficient to frustrate this court's review, and the response should be to send it back to make those findings so that we can make an argument that those findings were clearly erroneous. Because we think there is an argument here that it would be clearly erroneous to find the evidence satisfied the cross-reference.
So that's an alternative remedy, because first you said we should tell the district court you can't do this, but now, which makes total sense. You're arguing in the alternative. First we should tell the district court it can't do it. In the alternative, we should say do it again. Is
Correct.
there? Okay.
Yes.
Okay.
So with that said, the district court's finding that the offer of money for specific conduct To apply the production cross-reference was error, and we've asked this court to reverse the sentence, vacate it, and remand for resentencing. If there are no further questions, I will rest.
Thank you so much,
Thank you.
counsel. Appreciate you. All right, we'll come down, greet counsel, and proceed to our next case.
exception under Hall. And second, Mr. Hawley pled a pattern of misconduct that independently satisfies the imminent danger exception.
When you say pled, do you mean in the original motion or in the Rule 59 motion?
He pled imminent danger in both the amended complaints and the documents before the district court, as well as the Rule 59E motion to alter or amend the judgment.
Okay. It would be helpful for me if, when you're discussing the evidence, if you specify the evidence that was in the initial motion versus things that were in the Rule 59, because this is probably only something that a former Civ Pro person would think. I'm not sure you can consider evidence submitted only at the Rule 59 when attacking the dismissal of the original motion.
Absolutely, Your Honor. I will absolutely go through both where my allegations are coming from. I will point out that we do argue that this court can consider the allegations in the motion to alter the judgment because they are not new arguments. They are a continuation of Mr. Hawley's former arguments.
Okay.
How does our decision in Hall impact the way you approach this case?
Impact the difference between the motion to alter the judgment or the...
And the reconsideration?
I'm not sure if Hall, because Hall was somewhat distinct in that sense, in that there was not, I don't believe there was a motion to alter or amend the judgment. And the court there remanded because the plaintiff in Hall had submitted his medical records to the Court of Appeals, but not to the district court. So the Court of Appeals found his allegations sufficient to remand.
So you got allegations that a motion can reconsider, you got the original ones. Are the standards of review different?
The standards of review are
So
different.
what would it be for the reconsideration allegations?
For the motion to alter the judgment, it would be an abuse of discretion standard. So it would be, if this court were to find an abuse of discretion that the district court did not find a clear error of law.
Well, but a clear error of law, a district court commits a clear error of law in reference to a specific ruling in a specific record, right?
I believe so, Your Honor.
What I say is, a district court can't have committed a clear error of law in its ruling by not considering evidence that no one presented to them, right? It's not a clear error of law to disregard evidence that wasn't presented to the court.
I would push back, Your Honor, on the fact that the evidence was very consistent with what he had.
No, I understand. It's just a purely factual basis. I mean, let's give a stylized hypo that doesn't require you to give away anything about this case. So in opposition to an original motion, I say don't grant that motion because of X and Y. The court says, I'm going to grant the motion. And then in a motion under Rule 59, someone says, well, also X, Y, and Z. That's a clear error of law. And we would say, that's not a clear error of law. You can't rely on Z in arguing the district court committed a clear error of law in not considering Z, because literally no one ever presented Z to the court when it ruled on the original motion, right? So the alter or amended judgment inquiry is, did you make a clear error of law in denying the motion you had before you, right?
Yes, that is correct, Your Honor.
Okay, and then when you try to present new evidence in a Rule 59 motion, I mean, again, high level of generality, you can't use Rule 59 motions generally to present new evidence, and so one of the considerations under Rule 59 is, if you're giving me new evidence at the Rule 59 stage, you're gonna have to give me some reason why you couldn't have presented this before. You agree with that too?
Yes, Your Honor.
And you agree here the district court could probably, and I think did find, you don't really have any good explanation why the new evidence at the 59 stage wasn't presented originally, right?
I would push back in the sense that the allegations, again, are in the motion to alter the judgment.
No, I understand. That's about the facts of this case. I understand. But as a broad matter, if a district court says, Rule 59 motion denied, I will not consider Z in adjudicating this Rule 59 motion because you've given me no good reason why you couldn't have presented Z originally. That would not be an abuse of discretion
Yes.
under that stylized typo. Okay, thank you.
Yes. So moving to the specific allegations and how this court is similar to Hall. First, Mr. Hawley pled 2 ongoing serious physical injuries related to his worsening chronic asthma and permanent disfigurement, pain, and reduced function in his hands and wrists. Under Hall versus United States, for chronic conditions, a plaintiff must show that they are continually denied necessary medical care, which has worsened their chronic conditions, and that as a result, they are experiencing serious physical injuries or severe bodily harm. The facts in Hall involved a petitioner that had alleged the government had failed to provide him with the requisite standard of care for chronic asthma, COPD, and other conditions, and the court remanded his case to the district court to reconsider his allegations in light of the full record. Here, Mr. Hawley has similar allegations to those in Hall. Mr. Hawley, mainly he alleged that he experienced multiple delays in medical care and that the delays exacerbated his chronic asthma and caused him serious injury, threatening his life.
Can I ask you about a difference between this case and Hall? So my understanding, it was pretty important to our decision in Hall that the plaintiff was not getting medical treatment because his appointments were repeatedly canceled for years and his condition got worse when he wasn't getting medical treatment. But here it seems like your client did get medical treatment, right? Because it doesn't appear disputed that he got some medical. His claim is I didn't get it enough, I didn't get the right treatment. That's very serious, but like, in Hall, it was like, the injury was, I need medical treatment, they keep not giving medical treatment, no one's giving me medical treatment. Here, it seems at minimum undisputed that the plaintiff got some medical treatment at some points, right?
That is correct, Your Honor. So,
Why doesn't that distinction matter?
well, in Hall, just to restate what Your Honor said, the plaintiff had alleged that he had an initial medical appointment and but no additional appointments after that, and they were canceled for a year. And I would point this court as the key inquiry to the allegations of the petitioner in Hall that the government had, quote, failed to provide the requisite standard of care to treat him for his conditions, chronic asthma, COPD. So here we have initial delays of medical treatment following the initial transport of Mr. Hawley in a cage in 35-degree weather with no heat for 6 hours. And then there were delays in medical care, and then after that we have an effective denial of treatment, and that the treatments are not effective, and Mr. Hawley's allegations have shown that. So moving to the initial delays in medical care, Mr. Hawley, after he was transported in the cage, prison officials were dismissive of his health problems following that oral surgery. So he first, on November 4th of 2018, a few days after the oral surgery appointment, he went to the sick call nurse complaining of nosebleeds, and the sick call nurse dismissed the nosebleeds as normal. 3 weeks later, Mr. Hawley came back suffering acute shortness of breath.
All of these allegations are in the original? Or are you starting to add in things that are in the Rule 50?
Oh, I apologize, Your Honor. These are all in the original and or the admitted complaint. And I will point out.
But not the Rule 59, okay. Nothing you've said so
yes.
far, okay, thank you.
Yes, Your Honor. I will.
Appreciate it.
Apologies. I will
No,
make sure
just want to make sure.
So he does admit that at that point he did get an emergency breathing treatment, but then he alleges that the sick call nurse commanded him to refuse medical housing, and he alleges that he was told that the physician would be at his cell 2 days later. It wasn't until 3 days later that the prison officials found Mr. Hawley on the floor of his cell suffering. He says that he was, quote, nearest death, suffering, quote, severest bronchospasms, life-threatening breathing, asthmatic wheezing. That is, when they rolled them out, this resulted in a multi-day hospitalization and eventually a pneumonia diagnosis. And still in the motion to amend or alter the judgment, Mr. Hawley, the continuing ongoing effects of these symptoms, Mr. Hawley alleges he attaches a regular grievance from December 2019 to his amended complaints on page 31 and 39 of the joint appendix, in which he describes an incident in which, in December 2019, in which he was awoken, suffering.
December 2019 is at the time of the original complaint, right?
December 2019 is about a year after the original complaint. So we have a 2-year period, and this.
Sorry, not the, but before or after the district court ruled on the initial motion?
This is before. This is all before the district court had ruled.
So this could have all been presented in the, so this, we're now talking about stuff that's in the Rule 59 motion that had happened before the district court made its original ruling and could have been presented to the district court before its original ruling.
It was presented to the district court.
Oh, I'm sorry, you referenced the Rule 59 motion. I'm sorry.
Oh, yeah, I apologize.
No,
It was,
I probably got confused.
So this may help. If it's page 65 of the joint appendix or before, that is before the district court's
thank you.
order.
Yep.
And then when the motion to alter amend the judgment is in the 80s of
Got
the
it.
joint appendix.
Great.
So on page 31 and 39, he attaches these regular grievances from 2019, describing an incident in which he awoke suffering acute shortness of breath, a racking cough every 12 to 14 minutes. And he states that he has, quote, no confidence in diagnoses which amount to nothing at all. So those allegations are all in before the district court's initial order, not in the motion to alter the judgment. If this court were to consider the allegations in the motion to amend or alter the judgment, there's even more significant evidence that is consistent with the previous evidence, but clearer statements in which Mr. Hawley states that he had ongoing deteriorative effects of pneumonia, and he references a, quote, daily fight to stay alive. He states that the lung damage is ongoing. And he attaches a couple more grievances in which more delays of medical care, in which one request for a breathing treatment was ignored for 8 days, and another request for breathing treatment was not responded to for 11 days.
So one last question on Hall. So you quoted that requisite standard of care that was in Hall's complaint, but the court's opinion in Hall doesn't say that's the standard for imminent danger, does it?
The court's opinion in Hall does not state that is the standard. And the standard that's stated in Hall is that for chronic conditions, there must be a continual denial of necessary medical care, which worsens the plaintiff's conditions, resulting in serious physical injury or severe bodily harm. And Mr. Hawley has alleged with respect to the chronic asthma, both of those under the standard.
I have a question about the pattern of misconduct allegation, which I think is your second. Is that right? Okay. What is your best authority for the proposition that general allegations of the sort of allegations of misconduct that you plead here are sufficient? What would you say is your best authority for the proposition that that's enough?
I think the best authority that is enough is Newkirk versus Kaiser, which is an opinion from this court. In Newkirk, there was a plaintiff that described one incident in which he was allegedly subjected to excessive force and asserted that this was not an isolated occurrence. And the plaintiff claimed that prison staff members regularly assault inmates without cause and threaten inmates who complain. And together, that constituted a pattern of misconduct evidencing likelihood of imminent danger.
So that's an unpublished opinion, right?
Yes, Your Honor, it is unpublished.
Okay. What's your best published authority for that proposition?
I would point back for published authority, I would point back to the statement in Hall in which the standard is outlined, but the court did not analyze the allegations in Hall under the pattern of misconduct. But Hall did state, quote, we have also clarified that if there is a pattern of past conduct that places an incarcerated person in imminent danger of harm and which is ongoing, then the litigant meets the exception. So the standard is outlined for published opinions in Hall, and then in Newkirk, and then also Johnson versus Warner, another unpublished opinion in this circuit. Those help to flesh out what does a pattern look like. And so moving to the pattern here, all of the incidents alleged in the pattern that Mr. Hawley alleges, they all share two common traits, making it sufficient to form a pattern. First, they all emanate from the use of excessive force. So excessive force of Mr. Hawley being the initial cage transport, and then after he was transported, he was lying in the hospital bed. Prison officials handcuffed him, he alleges, too tightly, resulting in half-inch deep wounds, 13-inch long gashes, swelling to 3 times his normal size, and resulting in ongoing complications with his hands and wrists, which the district court, going back to the ongoing serious physical injury, did not address whether that could constitute chronic injuries under Hall. Moving back to the pattern, So those two incidents, the first two incidents involving Mr. Hawley, all involved excessive force. And the further incidents, Mr. Hawley attached in the objections to the answer on page 62 and 63 of the joint appendix, he attached a Richmond Times Dispatch article in which 3 other instances are described in which prison officials subjected other inmates to excessive force, such as attacking an inmate upon the inmate's arrival at the prison, and refusing to classify the inmate as mentally ill despite multiple diagnoses, severely beating an inmate and immediately placing the inmate in isolation, and verbally abusing an inmate and giving the inmate wrong medication. And I think it's important to note that one of the inmates as detailed in that Richmond Times article that Mr. Hawley attached the objections to the answer, states, quote, "I just want this place to do what they're supposed to do and stop beating on people. I'm not the only person that this has happened to. It happens to a lot of people." So first, all of those incidents involving Mr. Hawley and the others all involve the use of excessive force. And the second key connection that creates that connectivity between the incidents and the pattern are that they illustrate how the defendants treat inmates who are perceived to be disruptive. So for Mr. Hawley, that was for writing grievances. Mr. Hawley actually alleges that the initial the way he was transported to the oral surgery appointment was retaliation for him writing a previous grievances for the delay in his oral surgery appointment. He also states that they wanted to, quote, humiliate him. They had a, quote, heinous dislike. And I quote, when he asked for a breathing treatment, one of the officers responded, quote, "If you ask me again about your damn breathing treatment, you'll get your taste of Wallens Ridge State Prison's beatdown." So this evidence
Where's that in the J?
That is in the motion to alter the judgment and joint appendix, page 83 of the joint appendix.
Okay, I was pretty sure that was in the motion to alter amend.
Yes, Your Honor. But I will say the humiliate and the heinous dislike quote are in the amended complaint and the objections to the answer, respectively.
So the connection between the abuse on the other inmates and the alleged abuse against Hawley, are you saying there's some level of systematic retaliation that's a part of this?
I see I'm out of time, Your Honor. Is it
Yes,
okay?
you may answer.
Thank you. Yes, I think we are saying that, Your Honor, and that there is a pattern that has been evidenced with respect to Mr. Hawley and the other inmates, and that they treat inmates who are perceived to be disruptive with excessive force. So that was with respect to Mr. Hawley, but with respect to the other inmates, as to why we believe that they were seen as disruptive, they were writing grievances, practicing their Muslim religion, causing a disturbance in their pod, or causing a disturbance at another facility, and all of the incidents of excessive force followed those initial, those things, evidencing that there was an intent to retaliate, and they perceived those inmates as disruptive. Thank you.
All right. Thank you, Mr. Poppy. Mr. Dingman?
Good morning, and may it please the court. Michael Dingman, Assistant Solicitor General on behalf of appellees. With me at council table is Kevin Gallagher, Principal Deputy Solicitor General. Garfield Hawley has a proven history of filing frivolous lawsuits. Congress enacted the PLRA to prevent frivolous lawsuits from clogging the federal court system, and it prevents plaintiffs like
Is it in
Hawley.
dispute that he has the strikes?
There's no dispute that he
That's
has
what I
three
thought.
strikes.
Good.
And the act bars plaintiffs like Hawley from proceeding IFP under those circumstances unless he is in imminent danger of serious physical injury. But nothing in Hawley's complaint alleges imminent danger of serious physical injury, nor do his other filings reveal one.
Can we consider the allegations in the reconsideration motion?
Under Bannister v. Davis, Your Honor, no. At least the ones that predate the court's decision to revoke IFP status, because Hawley could have raised those factual allegations before that ruling.
What about Hall? Hall looked like we considered some records that were only presented on appeal.
Your Honor, this court didn't consider that in making its decision. It remanded so the court could consider those records. It noted that the district court did not have the benefit of the medical records when it rendered its initial decision. And so this court in Hall did not hold that the plaintiff had...
But wait, but under your understanding of, I mean, that seems like worse, not better. If you can't present new evidence in a 59 motion, it would seem a fortiori you can't present new evidence on appeal, right?
That's true, Your Honor, but the issue in Hall was that the plaintiff there had provided specific allegations that this court decided met the standard under the statute, but then remanded for further consideration in light of the medical records. So here, there are no such allegations because Hawley simply alleges ongoing effects of past injuries. He's not alleged that he's in danger of he's in any imminent danger of serious physical harm in the future. And that's what this court explained in Hall. In Hall, this court said that a theory of delay or denial of medical treatment must worsen a petitioner's medical condition, resulting in serious physical injuries. It's not simply that there are lingering effects of ongoing injuries or that a plaintiff may prefer different types of care. There must be specific and sufficient allegations establishing that the delay or denial itself is putting the plaintiff in imminent danger. And again,
To sort of put it colloquially, like, so something bad happened to me, and it's not the something bad that's going to get better with time. It's the something bad that's going to inevitably get worse with time if we don't do something about it. So, like, every single day we don't treat my broken arm, it's not just that my arm is not getting better, my arm is getting worse.
That's exactly right, Your Honor. And the cases that hold the plaintiff meets the imminent danger standard generally involve diseases like HIV, hepatitis C, diseases that if they go untreated will result in a serious physical injury like organ failure or death. Van Diver is an excellent example of this. The plaintiff there provided detailed allegations that he was diagnosed with diabetes, provided detailed allegations of what a physician had prescribed for him, alleged that the prison had not provided him any of that treatment, and then also alleged that because the prison had denied him that treatment in the past, he had to undergo partial amputations. But that was not enough to meet the statute. What made it enough to meet the statute was that the prison continued to deny treatment, which put him in future danger of having further amputations. And so the issue here is that all that Hawley alleges is that he has lingering breathing problems from his chronic asthma and his pneumonia infection, which are being treated as he concedes in his 59E motion. He's had over 100 breathing treatments and is receiving medication for his lungs. He alleges that he has ongoing pain and sensation issues in his wrists, but he admits in his response to the motion to dismiss that he was treated for his wrist before he even was discharged from the hospital for his pneumonia infection. And while he may subjectively disagree with the type of treatment, as the Third Circuit held in Ball v. Famiglio, that's not enough under the statute unless there's a specific allegation establishing that, if true, that treatment is so inadequate that it will create an imminent danger of serious physical injury in the future. But that's simply lacking here. As for the pattern of misconduct, Your Honor, there's simply no nexus between the misconduct that Hawley alleges is putting him in imminent danger at the time he filed his complaint and the allegations in the complaint. This court explained in Hall that there must be a nexus because of the design of the PLRA and the three-strike rule, and the imminent danger exception is a safety valve to this three-strike rule. Here, Hawley alleges that he was injured by the conditions of a medical transport and he was handcuffed too tightly while in the hospital. Meanwhile, his allegations of pattern of misconduct are simply allegations by other inmates that they had been assaulted at other points, but that is a direct conflict, if this court were to hold that that's enough, would directly conflict with the D.C. Circuit's holding in Mitchell. There, the plaintiff alleged that he had testified for the government. He had been placed in a prison known for assaults against government witnesses, and he alleged he had been assaulted in the past, 17 months before he filed the complaint. But the court held that these sort of generalized allegations about the nature of a prison being known for assaults or not were not enough to satisfy the statute. The Third Circuit explained the same in Abdul Akbar. There, the plaintiff alleged that he had been unlawfully pepper sprayed, and that he alleged other instances of guards physically harassing inmates, but the court held that that was too generalized and disconnected. So the level of generality is a line drawing problem, but it's an important one here because of the statutory context. The statute requires it provides a disincentive for prisoner plaintiffs to not file frivolous lawsuits, and that disincentive is only effective if the exception is not interpreted so broadly that all that's necessary to circumvent the rule is an allegation that other inmates have been assaulted, and that's not enough under the statute. And just to clarify one point about the record, Your Honor, the amended complaint ends in November 28, 2018, with Hawley's discharge from the hospital. The latest date stated is November 27th, but I think it says a day later, so November 28th. His one attachment to that is a single night in December 2019 where he alleges he had breathing problems and used his inhaler for those, and does not assert that his inhaler was ineffective or that he was denied any treatment he requested because of that event. And so anything after that is, in the Rule 59E motion, is, as Your Honor is pointing out, not fair game under Bannister v. Davis, because it would be improper to fault a district court for ruling on issues that were not presented to it. And again, just to close, Your Honor, the statutory background of this case is crucial, and that's something that's missing from Hawley's briefs. Congress noted a significant societal problem when it passed the PLRA. It noted that frivolous lawsuits were clogging the federal courts, and as Judge Wynn put it in Taylor v. Grubbs, preventing district courts from considering more meritorious claims. And so it enacted the PLRA to weed out the bad claims and prioritize the good by providing a disincentive for plaintiffs to file frivolous lawsuits. That disincentive is the three-strike rule. And adopting Hawley's arguments here would render that rule too broad, which means that frivolous lawsuits would, again, be too easy to file and would undo the congressional scheme. This court has no further questions. We'll rest on our briefs and ask that you affirm.
What about the fact that he says that because of the conditions he was in, his lungs are such that he struggles to daily survive in terms of breathing? What is that seems to be some imminent, I mean, I would think not being able to breathe is pretty imminent, isn't it?
Your Honor, we're not disputing the seriousness of the injuries in the past, but the statute is concerned with whether he's in imminent danger of a serious physical injury in the future. And so when considering that
Well, he is. He's asthmatic, right? People who have asthma, they don't just, one day they have an attack and all of a sudden, you know, they're fine. It is a chronic disease, right? And then what he's alleging that the conditions of which I'm being confined, I am chronically exposed to asthmatic attacks. If you know anything about an asthmatic attack, at the point of it is, it can be deadly. This is lethal. It's not a matter of, oh, my chest hurts. No, you can't breathe. But how imminent do you have to do? Die first, or what?
No, Your Honor. Two responses to that.
Go ahead, please.
The Seventh Circuit expressly rejected allegations of a.
That's a fine circuit. I know the judges very well, but they're not quite in the Fourth Circuit. So give me some precedent in terms of that. I know you said DC Circuit. I'll let you go with that.
Well, again, Your Honor, the DC Circuit hasn't addressed asthma specifically,
I know.
but.
Go ahead. Go ahead. If you want to cite that, it's a wonderful circuit. Go ahead.
Okay, Your Honor, Sanders v. Melvin, there, the Seventh Circuit explained that a plaintiff who alleged two different imminent dangers. One was of, he said, a struggle to breathe from asthma from the conditions of his confinement. It said that was not enough because many harms for many people, including asthmatics, do not end up being serious or do not wind up occurring. And there is no specific allegation in the complaint that showed that any serious injury was imminent from that asthma. It's the same issue here. Hawley alleges that he's being treated for his asthma, which, as the 10th Circuit explained in White v. Colorado, renders the idea that serious injury is imminent is less plausible under those conditions. And also the Seventh Circuit in Sanders explained that the other harm was a danger of self-mutilation because the prisoner there had a diagnosed history of mental illness, past attempts at suicide, past self-harm, and was not being treated allegedly under the terms of his complaint. And the court held that that was enough because he had specific allegations showing that there was a risk of serious physical injury in the future. Here, Hawley West.
In this case, is there some allegation there's some animus that may be racial reference in this case?
Your Honor, that is alleged, but the fact that
Don't we have to take it forward? We're not trying this case. It's a question whether or not we're gonna allow him to have the $300 and some to not have to pay that to file his suit, right? We're not here for that. But isn't there allegations about, there goes a little song that was made about how Holly's black ass in terms, you don't recall it in the record?
Your Honor, I do recall that in the records. Much of that is in the Rule 59E motion, but I believe there is some alleged in the amended complaint. But the fact that a plaintiff is part of a particular class that's threatened is not enough under the Azamani case, or the Mitchell case, excuse me, for example, because there again the plaintiff alleged that he was part of a class of prisoners who was under particular threat. And then in the Azamani case, also from the DC Circuit, the plaintiff alleged that he was particularly personally threatened by his inmate enemies for various characteristics. The DC Circuit also considered, went through its previous.
But that's right. He's alleging that correctional officers said this, right? Not just other people, a class of people anger at each other, right? Isn't he alleging that correctional officers said this? Is he or not?
He has alleged that, Your Honor, but that's, again, does not mean that he's in imminent danger of serious physical injury at the time he filed his complaint.
What if someone said that to you? Wouldn't you be pretty frightened in terms of whether or not they're gonna help you? I mean, that's the whole point, is imminent is both, I mean, well, for example, nobody knows when they're gonna die, but there's certain situations that make it imminent that you think morbid reasons that it might. When you,
Yes,
don't
Your
you
Honor,
think
but
that's reasonable if somebody said that? Assuming that's true, you know the quote, what did they say? What did they say to him?
I don't have the quote in front of me,
You
Your
don't,
Honor,
well,
but I
find it,
understand what you're
find
talking
it then.
Of course, Your Honor.
Because we're here for whether or not it's imminent. I mean, that's the question.
Well, Your Honor, I'd say there's a difference between imminence and inevitability. So the idea that harm might occur is not enough under the statute. It must be likely to occur or impending in the near
Well,
immediate
they put him in
future.
a dog cage, didn't they? That's what you allege?
He alleged that happened, yes, in the past, Your Honor. It doesn't necessarily mean he's in
But the
imminent
past,
danger.
the past informs the present, doesn't it?
It does to an extent, but when there's
To a great deal of extent when, you don't want to read that language, do you?
I'm looking for it, Your Honor. Yeah, it's at JA 10, or that's the original complaint, excuse me. JA 10 is the original complaint where it's listed.
Original complaint, right?
Yeah,
That's right.
the amended complaint.
What did he say to him?
Your Honor, I prefer not to read it.
Well, no.
I acknowledge it's there, but,
Well, I didn't ask you your preference, you asked my question. It's the record.
okay, Your Honor, I'll read this.
We're talking
with-
about imminence, and you're talking about you want to call it because it's not tasteful? That's the whole question, whether or not this person should be allowed, not allowed to bring his action because he is poor, obviously without funds. And the question whether this court determine whether or not that's an imminent danger. Now, you're afraid to read it because of sensibility? Read it.
Your Honor,
Read it.
okay, this is as alleged, to clarify. On one occasion, G. Hawley overheard a correctional officer, John Doe, state, "There lays old Hawley, always riding up."
Always writing up, read it.
Am I allowed to curse?
I don't know how you could read what it says without reading what it says.
Okay, all right. "There lays old Holly, always writing up shit, bitching about no coffee and no juice. Good riddance, Holly dying cuffed up, non-stopped, your black ass to hell, ha ha ha."
Your black ass to hell. Ha, ha, ha.
But Your Honor, that does not establish.
That doesn't mean anything, does it?
Your Honor, this is not about the merits of his underlying suit. This is
Exactly,
about-
but it's about whether or not we're questioning whether or not the conditions of his confinement and what was said to him, what was done and what wasn't done, does inform whether it's imminent. And I'm asking you, that means nothing then? You in prison, you had formerly been transported in a dog cage, bounced around, and then someone says that, like you said, it's alleged, but that's what we hear. We're not determining the merits of it at this point. We're determining whether or not we're gonna allow him to waive $350 or so he could bring his action in a federal court. That's what we're here for.
Well, we're here to see if this court, to get this court's interpretation of the PLRA. It's a broader statutory scheme, and any individual case might seem small,
It's
but the
broad,
broader
but
picture.
justice is right here in the facts of the case. That's what we determine justice in terms of adjudicating the case. And what I'm saying is that means nothing in terms of that being said. We have to assume that
We're
was
not saying
said.
that means nothing, Your Honor, that we're.
What does it mean then? Is that imminent? Imagine if you were locked up and, someone said that to you, and then you've already been transported in a dog cage, as we allege, a cage for an animal, and then you're told that, what's a black, yes, go to.
Your Honor,
say, ha, 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 ha.
these are allegations, and allegations in a.
That's what complaints are, allegations.
And this is a statute that deals with plaintiffs who have a history of filing frivolous allegations, baseless and
And
malicious
that
allegations
has
on
nothing
pre-prior.
to do, this could be his 100th. The question is whether or not he is in imminent danger, not how many he's filed in the past. That's when you started off with your argument. I say, it's no question he has 3. So I'm just asking you, you're telling this court that that means nothing. I mean, if that's your argument, I'm not disputing. I just want to make sure you say it. That doesn't matter, right, in terms of imminent.
It would be
That's the government's, I want the government's position on that. That doesn't matter.
Your Honor, whether someone is in imminent danger of serious physical injury, as this court explained in Hall, is a combination of all the facts and all the circumstances, and a district court has broad
And
discretion
I'm
to
asking you
consider.
about that fact as alleged.
I would say that as alleged, that fact would show that one particular unidentified correctional officer harbored animus towards Hawley because of his race. And that does not necessarily establish that he is in imminent danger of serious physical injury, particularly because he does not
Well,
identify.
he's gonna be black the whole time he's in there, isn't
Your Honor, that's, again,
he? Is
that,
he?
he does
Can
not
he
allege,
change that? Can he change that?
he does not allege that at the
He
time
didn't
of
say,
his
like, if you
complaint.
don't, he didn't say, if you don't stop misbehaving, blah, blah, blah. But he talked about, it was a reference of fouling, and I don't wanna say it because we've tested your sensibilities already, but fouling stuff, it was a reason that prompted, that's alleged, that's what I'm saying.
That's similar to what the plaintiff alleged in Mitchell, Your Honor, which the DC Circuit rejected. The plaintiff there alleged that he was someone who had testified for the government, that he was in a particular danger because he was in a class of persons who had testified for the government, that the prison he was in was known for assaults against plaintiffs who testified against the
That's
government.
generality, this is particularized to him. They named his name, he was mentioned talking directly to him. That's a different fact, that's different.
Your Honor, I guess the question is then, is Hawley then excused from the 3-strike rule going forward because he will always be able to allege that this occurred, which means that he could always allege that he's in imminent danger if this court buys his theory of this case, which
Well,
means that the 3-strike rule doesn't apply
That's
to
your
him.
slippery slope argument. I don't know about that, but I know we have to deal with the facts before us. I don't know whether he'll do it or not. I
In the-
don't know. Basically, I could do that on anything, whether I thought it was merit or not. Well, you know, if we allow these things, there'll be more and more people coming. Is that appropriate for the government said the slippery slope is enough? I hope that this is rare, as he alleges, that people say that, as you know, as you can attest, you were afraid to even say it in court, wasn't even your words to read it. Let alone, can you imagine being locked up and have no control over your being, your safety, or anything else, what there would be presented to you? I suppose, that's why I asked you again, does it mean nothing for imminent danger?
Your Honor, if that's the theory, then I struggle to see a limiting principle that would not allow just about any prisoner plaintiff to bring a case and avoid the 3-strike rule, which would eviscerate the
Wow.
congressional theory.
I hope you're wrong, that this kind of behavior would be so common that it would be a floodgate. Go ahead, you have anything else to say?
No, Your Honor, just ask the court of
All right, thank you. Mr. Poppy, you have some time reserved.
Thank you, Your Honors. I'd like to first clarify, just to make sure that it's clear for this court, that the comment made by the prison official with the racial undertones was in the original complaint and both admitted complaints, so page 10, 28, and 37 of the
Right.
joint appendix. And then to address Apley's argument about the Mitchell, the DC Circuit case, in which the court said that there were generalized allegations and they faulted the plaintiff for making vague and unspecific allegations. Here, with respect to the pattern, with all pathways, there were specific allegations, but looking particularly to the pattern, there was specificity of all of those allegations. With the first, he described in detail the initial cage transport, the handcuffs, and the continuing effects with the asthma and the ongoing hand and wrist injuries that he experienced, and the repeated failures of the prison officials to give him the requisite standard of care. And I'd like to point this court to a quote that Mr. Hawley alleges that Assistant Warden Combs was, quote, aware of over 20 years of credible inmate complaints, attorney complaints, and family complaints about Wallens Ridge State Prison's correctional officers' excessive use of force on inmates as a means of punishment and not for legitimate reasons. So Mr. Hawley is specifically alleging that there is animus from the prison officials towards inmates who they perceive to be disruptive, and he has specificity of all of the incidents that involved him and the other inmates with the Richmond Times-Dispatch article that he attached in the objections to the answer. Moving next to the arguments by appellees, the Seventh Circuit case, Sanders versus Melvin. Sanders involved a plaintiff who was suffering, he alleged that, quote, the isolation, heat, and restricted airflow in solitary confinement harmed him by aggravating his asthma. And he alleged a, quote, struggle to breathe. And the court said that normal incidents of asthma or a mere struggle to breathe are not enough. Here we have much more severe allegations than a struggle to breathe or simple incidents of asthma. Going back to that initial instance in which he was lying on the floor of his cell, Mr. Hawley stated he was, quote, nearest death, suffering life-threatening breathing injuries. And all of this is before the motion to alter the judgment with that initial incident. So we have much more than a mere struggle to breathe or normal incidents of asthma. And I'd also like to point out that Mr. Hawley was 65 years old at the time that he filed his complaint. And this is not in the briefs, but the American Lung Association has stated that 65 years old and older chronic asthmatics are 5.9 times more likely to develop serious pneumonia, and then are more likely to develop serious ongoing complications after that. So we have severe, specific allegations with respect to the life-threatening nature. Next, appellees also referenced the Van Diver case, which is a Sixth Circuit case, in which there were things such as amputations, coma, different factual allegations than we have here. Hall cites Van Diver for the standard and relies on it, but the specific factual allegations here are very similar to what we have in Hall. Hall involved a plaintiff with asthma, COPD, another lung condition, and the court found that sufficient to remand to the district court to consider whether, in light of the whole record, that constitutes imminent danger. Here, we again have chronic asthma, severe chronic asthma, life-threatening injuries, and that puts this court very similar to Hall. And then lastly, I would just like to touch one more time on the injuries to the hands and wrists. The district court did not address whether the hands and wrists could constitute a serious physical injury, an ongoing serious physical injury under Hall, and it should have, because Mr. Hawley alleged that he received insufficient care. In the weeks following that initial injury, he saw a doctor, but no gauze or bandages were applied, and 5 days after, they stopped giving him medication for his hands. And Mr. Hawley has alleged ongoing hand and wrist pain, throbbing, and nonstop electric tingling, both wrists, and loss of grip daily, all before the motion to amend or alter the judgment. And he has stated that the injuries necessitate treatment from a nerve specialist and physical therapist. And there's no indication in the record that he has received that treatment for the hands. So Mr. Hawley has alleged 2 ongoing serious physical injuries related to his worsening chronic asthma, and the injuries and the permanent disfigurement to his hands and wrists. And he has also alleged a pattern of misconduct that evidences a serious,
It just seems to me that a case like this, the issue here is whether he should be given an informal pauper status. You have the PLRA that was put in place to streamline these cases, and yet look what we're doing. We spent all this time with the district court going on and on about whether this guy should be able to go informal paupers. We've had a hearing up here going on and on about it. We could probably resolve this thing just letting it go forward without going through this. I mean, but, you know, I guess if we do, then we just let everybody through. But it seems like there should be some standard that maybe this is one of those instances in which, I don't know if we do it from this instance or whether it comes from the legislative side of saying, you know, in the interest of judicial economy, a term I used earlier, a court ought to do that might streamline a case more so than to go through what we're going through now. Because at the end of the day, even if we go for what you're going for, if we grant you this relief, your client gets no relief. All he gets is to go back and now go through the proceeding. There's nothing going to happen here other than saying he gets a chance to be heard. And that really sounds like we're just spinning wheels up here to me. But there are some important points here that will affect other cases. And I recognize that. So thank you for your time.
Yes, Your Honor, thank you.
Thank you, Mr. Poppy. Mr. Birch, I want to make sure you give it due. Please introduce these litigants, fine litigants for the court. Come on up. Come on up.
Thank you, Your Honor. I'm Thomas Birch from the University of Georgia, and you just heard from Mr. Poppy, Zach Poppy, who's a 3L in my appellate clinic at the University of Georgia. And along with him on the brief was Ms. Taylor Stabline. both helped me write the briefs, both helped prepare for the argument, and of course, Mr. Poppy presented argument today. Thank your honors for letting us do that.
Well, thank you so much. It was well done. Those Georgia Bulldogs acquitted themselves well today.
Thank you,
And,
Your Honors.
And also, too, I note that you were court appointed, and we appreciate the work. Mr. Byland.
Yes, good morning, Your
Good
Honors.
Good morning.
Jeremy Byland on behalf of Point Click Care. Your Honors, over 1.6 million nursing home residents in North America rely on my client's medical software being safe, secure, and available. And that's why my clients have had a long-standing contractual prohibition that predates this dispute that prohibits the use of automated bots on its system. And that's because those bots can crash the system, which can cause life-threatening issues for the nursing home patients.
Mr. Byland, I'm going to have some questions about your client's bot policy, but I have some questions, unfortunately, before that.
Sure.
You're the party that removed this case, right?
Yes, Your Honor.
What's the basis of federal subject matter jurisdiction?
Diversity jurisdiction.
Okay, because you agree it's not arising, so the notice of removal cites both arising under and diversity, and it's clearly not arising under because the CARES Act doesn't create a cause of action, and because the Declaratory Judgment Act doesn't create federal subject matter jurisdiction, right?
So the complaint as filed in the state court tried to bring a cause of action under the Cures Act. And so we agree with you that there's not a right of action under the Cures Act, but because the original complaint had that cause of action, which has now been, well, it's been abandoned, it's not being
Okay, so at the time of your notice of removal, you alleged that the other side was an LLC, right?
That may be the case, Your Honor.
Real-time medical systems, well, no, so their complaint says, you allege they were an LLC, I'm pretty sure? And you said you were unaware of the citizenship of all their members, which matters because LLCs take on the citizenship of all their members, right?
Yes, Your Honor.
Okay. Did you ever become aware of the identity of their members?
I have not, Your Honor.
Does that mean you failed to establish the existence of complete diversity?
I'll get back to you that on rebuttal if you don't mind,
Great.
Your Honor.
Because the only thing I'd like you to get back to me on rebuttal too is some of the filings refer to them as Real-Time Medical Systems, Inc. So corporations are the state of,
I mean, standing here, I believe they're an incorporation, but I want to get back to you.
okay, I appreciate it. So, thank you. No, I appreciate that. Okay, yeah. So on the bot policy, I have just a question literally from reading the briefs that I don't understand.
Okay.
Your client has always had an anti-bot policy, right?
It has yes, a contractual
Between
prohibition.
2014 and 2022, did you do a single thing about their use of bots?
Between which dates, Your Honor?
2014 and 2022.
Yes, we did, Your Honor. We dialogued with our customers that were using bots in our system and encouraged them to not allow bots on their system, and that proved ineffective, and that's why we started implementing CAPTCHAs in 2022.
Okay, so it's always been against, okay, because it just seems, we have a policy against bots, you can't use bots, everyone's been using bots for years, but then in 2022, we all of a sudden started using these CAPTCHAs.
There were actions taken, Your Honor. So there's been like this cat and mouse game that's been going on for years. So it started with dialogue with our customers, then it moved to CAPTCHAs, and then the opponents had a full-time employee whose whole job was to defeat those CAPTCHAs, and so the CAPTCHAs proved ineffective. We then implemented more effective CAPTCHAs, and that's when the preliminary injunction motion was brought.
Okay, so one more just framing question before we get to the district court. So as I understand it, there's a lot of talk about these exceptions, right? But these exceptions only apply once we have information blocking, right? There's a prohibition on information blocking and then says you can information block in certain exceptions, right?
Yes, Your Honor.
And I read your brief as arguing the
Well,
exception.
Can I take to the little issue?
Please, of course.
The exceptions say that's not information.
Sorry, not information. They
Yes.
carve out, sort of like like Rule 801 of the Federal Rules of Evidence says, here's certain things that are hearsay, and then here's a bunch of things that would otherwise be hearsay that are now not hearsay. Okay.
Right.
So you've never argued, you've only argued the exceptions. You've never argued that absent the exceptions, this wouldn't be information blocking.
Correct.
Okay, thank you.
So, but I guess, and this gets to the burden of proof argument, which I'll get to. I don't know that that matters.
No, I'm just trying to frame what is in front of us and what's
Right.
not.
So I wanted to just first start with the misinterpretation of the Cures Act by the district court. So the injunction prohibiting us from blocking bots, prohibiting us from enforcing our contractual prohibition is based on a misreading of the Cures Act. And I think that's most evident in the interpretation of the manner exception. So in the manner exception, when you have a non-standardized request for access like we have here, what the manner exception provides is if the parties can't come to a mutually agreeable terms, then my client can offer two federally recognized alternatives. And if we provide two federally recognized alternatives, then we have satisfied the Cures Act.
But you use the manner exception for the bot, and the district court seemed to have been pointing to that data export as a basis by which they could also come there. And that was something they offered. How do we get there? I mean, when we look at it from the proper manner in which it's requested in this instance.
So
if it didn't come together, how do we get to the agreement business?
So if your honor's asking about the request for a data export in CSV by RTMS, is that what you're referencing? That doesn't actually, that's also non-standard. So it's not part of 170. Part 170 has very detailed specifications by the federal government about content, about manner, and that CVS export is also non-standard. So the bots are non-standard, the CVS export is non-standard. So then the question is, what happens when we receive non-standard requests? The Cures Act says that if we receive non-standardized requests and we don't come to mutually agreeable terms with the other party, then we can provide the federally recognized alternatives. And the error by the district court was by not letting us get into that exception by saying that we were merely unwilling and not unable to come to mutually agreeable terms.
Can I ask you to accept, so part of what's going on in this case is there's these three exceptions, and everyone's debating. And I look at these three exceptions, it would be helpful for me, and I'm gonna posit that these exceptions can overlap and that they have overlapping concerns, but like at a really high level of generality, could you tell me what you think of as the big picture idea behind each of the three exceptions that are at issue in this case? Like, what are these trying to get at?
So the manner exception is trying to get at favoring interoperability and scalability against bespoke solutions for every request that comes in the door. And no one said that pretty explicitly in their 2024 rule.
And so the equivalent here is like a statute like FOIA, where the requester says, not only would I like this information, but I'd like this information in this hyper-specific way that I want. And the government agency says, like, but I don't keep the information in that form, and I shouldn't have to create a form that doesn't currently exist just to help you.
Correct.
It's that kind of provision.
And ONC explicitly in its final rule favored interoperability and scalability with the federal standards and disfavors the bespoke solution.
Mm-hmm.
I think the IT health exception is ensuring that when you have hits that are coming in on your system, that you have the flexibility to cut off that access so it doesn't degrade your system.
And that's IT. Is this IT or safety that says, like, you can take your system offline for a while if you need to do maintenance, and people can't argue that violates it?
IT health.
That's IT health, okay.
And then there's security that says that if you have there's two ways into the security exception. If you have a generally applicable policy, or if you have a specific security finding that you have a security threat, that you have the flexibility to address that security threat.
So that's just about security threats, qua-security threats?
Yes.
Okay.
So, but I think the court doesn't have to look further than the legal misinterpretation of the manner exception, because that actually is like fatal to the whole case. Because
no, I understand. I'm just trying to, because in interpreting the individual exceptions, at least I found it important to think about, like, what are each of these trying to do? Right, okay, thank you.
Yeah, and I think that on the manner, back to the manner exception, in January 2024, when ONC issued that's final rule, it clarified the fact that they wanted to reduce uncertainty in the manner exception. They wanted to make sure that if you were providing the alternatives, that you had the certainty that you were complying with the law. And that's the problem we have here, is this is creating uncertainty, right? Because in the record, we have an exchange of contracts, we have merger discussions, and yet the court below puts a thumb on the scale in favor of RTMS and says, no, you didn't try to come to mutual agreeable terms. But mutually agreeable terms mean they have to be agreeable to both parties. So that we think that that's legal error, and that the
So
whole
the legal
case-
error is saying unreasonable what the district court viewed as unreasonable failure to agree does not preclude a determination that the parties have been unable to reach mutually acceptable terms.
Correct. When you have a non-standardized request for access, I don't think that there's any good faith or requirement or anything of that nature. If the parties are unable to come to an agreement, you can use the alternatives. And I think it's supposed to be streamlined, it's supposed to have certainty so that the system will work.
But I'm
Moving-
bringing it back to the bot distinction I brought up, and you gave me an answer on it, and I've just been reflecting on it and trying to understand. Because the rule is pretty broad, it says, you know, you request something, and if you then look to see if it's something that you can implement, you can do, you need to be agreeable on it, but your witnesses didn't even talk about this. I mean, they didn't really get into whether or not it would be agreeable. And so the question really is, why isn't it a proper manner requested for which the parties should be able to reach an agreement? Not that you did, or not that you want to, you're able to do it. And that's really the conundrum, I think, at least insofar as when you're talking about the manner requested exception, how does that differentiate out? Because if they say, we can do this with the data export method, okay, not bot. If we stay with bot, you know, that's been a problem. They backed away from that. But then once they get into the data export method, the question then becomes, well, don't you have to say you can't or you're not able to do it? I mean, don't you witness at least need to address, is this a way in which we can have an agreement?
Your Honor, so there's two different ways into the manner exception. One is whether you can't do it, it's infeasibility, and the other is whether you're agreeable to it. So the trial court conflated those two. There's two different avenues. So we don't have to show that we're unable to do it. We just have to show that it's not agreeable to us to do it. To answer your question as to whether we engage in negotiations, our witness did talk about the extension negotiations and talk about the terms that were not agreeable to our client, including putting back into the contract the requirement that they be able to use bots, and then also knocking down the price to less than half of, or to half of what we requested.
So the language you're referring to, and I'm looking here, trying to see what it is, it says, unless the actor is technically unable to fulfill the request or cannot reach an agreeable term with the requester to fulfill the request, that's what you, and you're differentiating that. Well, I'm dealing with that one you're talking about, the one where you say you are unable to do it. And if you are unable to do it and they say, here's something, don't you need a witness to say it's not something you're able to do, at least in terms of unable, but then cannot reach the term, which is what you want to go and say you cannot reach the term. Cannot doesn't mean you don't want to reach the term. It means you just, I guess it's sort of the same thing in some way, you're not able to do it. It cannot just be, I cannot reach it because we just won't agree.
Your Honor, so I guess I have a couple responses. I think the word agreeable terms has meaning. It has to be agreeable, and if it's not agreeable to my client, then it's not agreeable. So, and I think that the problem with that interpretation is it's conflating the inability to do it, which is infeasibility.
So it can be a subjective determination, and that if it's not agreeable to your client, that's enough to create that exception there.
I think that's right, and if you look at ONC's rule, so this is 89 Federal Register at 1382, what ONC says is when you have these non-standardized requests that come in, the EHI platform doesn't have to agree to it. They can provide the alternatives, and they want it to give certainty and make sure that there is, that the EHI platform, when they've offered those alternatives, knows that they've satisfied that, and that's 171-204.
Now, the district court explicitly said you chose to end those discussions. Is that clear error?
What's clear error is the legally inaccurate premise that being unwilling doesn't get you into the manner exception.
But when the district court makes a determination that you chose to end those discussions, is that
That's
determination by the district court clear error?
That factual determination is, I guess we're not contesting that determination, but what our witnesses said is that the terms were unagreeable because, and back to your point, the reason they were unagreeable is because the bots were unacceptable. And so what they requested was unacceptable to us. And the injunction, to be clear, requires us to allow their bots on our system. So that's what we're here contesting, is that requirement that we provide the bots. If the injunction were something else, that we provide some other sort of data, we'd be arguing about that.
And that took care of the bots, but what about the data export?
The data export doesn't fall under the act because it's not Part 170 compliant. So it's not a secure way to, so ONC says if it's non-standard, you don't have to do that. You can provide this standardized, secure alternative, and we provided, or offered to provide at least 3 of those alternatives. Taking a step back, I just wanted to note that the Cures Act can't be a predicate for these state law causes of action in the first place. And that's true as a matter of Maryland case law. We cite the Waypoint case to you, where there's not a single Maryland case that allows a federal statute that doesn't have a private right of action to be used as a predicate. We also cited the restatement and this court's precedents on preemption.
Have the Maryland, I think I know the answer to this question, but it is my sense that the Maryland courts have never cited that restatement. Do you have any case that disagrees with that belief?
Your Honor, it's not in our brief, but I did find an appellate Maryland court that did cite the restatement.
It cites the 3rd restatement? That cites the restatement cited in your brief.
So I'm not, I think it was the 2nd restatement, not the 3rd
Sorry,
restatement.
the restatement that's cited in your brief, has that ever been cited by Maryland courts?
Not that I'm aware of, but it is what the trial court bases her opinion on, and she misinterpreted it, and as we read it, it doesn't support her position, it supports the opposite position. And then the last thing I would like to say is the court fundamentally misapplied the burden of proof. I think this kind of goes to your question earlier, Your Honor. When you have a general prohibition like this, where everyone lives in the carve-outs, and then you try to filter that through state law causes of action, that means that the other party should bear the burden the whole time, and there shouldn't be any burden shifted. And the Supreme Court just heard last week Cunningham v. Cornell that talks about ERISA. It's a very similar case, and this is also happening in the drug compounding cases. All the pharmaceutical companies are getting dumped out on motions to dismiss. So with that, Your Honor, I'll get back to you on on rebuttal on the LLC question.
Great.
Any further questions?
Thank you, Mr.
Thank you.
Ballard. Ms. Bruce?
May it please the court, I think it's still morning, maybe not, maybe afternoon. Good afternoon, Your Honor.
Good
We've
afternoon.
made it to lunch. I stand between you and the end of the day, so.
So, Ms. Bruce, before you start, can I
Yes,
just
sir.
ask you the question that's confusing? I'm looking at your state court complaint.
Sure.
The caption says Real-Time Medical Systems, Inc. And then I turn to paragraph 9 of your complaint, and it says Plaintiff Real-Time Medical Systems, LLC.
And
Which one is it?
I agree with you. So my client is here, and I asked her, when you asked counsel that question, she says it's an LLC.
Okay?
We do not have anyone who lives in Canada. This PCC is a
Or abroad.
Canadian
Or abroad.
company. Or abroad? No, no abroad. No Canada, no abroad.
Super.
So does that answer your question, Your Honor?
It does, thank you.
Sorry for the confusion, but we didn't contest jurisdiction when it was removed to the federal court because of the diversity of citizenship. We looked at that and didn't think it was worth our time to fight over whether or not there was a federal question. We do not believe there is a federal question that is implicated here. We believe we're only in federal court because of diversity jurisdiction.
Got it.
So
Thank you.
with that, Your Honor, I'd like to start with the question that you asked, if you don't mind me answering that. What is the overarching broad reason for these exceptions? And that is, the overarching broad reason for this entire act as it relates to electronic health records and health records is interoperability, right? How do we get information to flow between healthcare providers, hospitals, skilled nursing facilities, anyone who provides health care to these individuals, vulnerable individuals who need this care and treatment? My client is part of the healthcare team. We're not an outsider, we're not a stranger, we're part of the healthcare team. We are trying to get medical records that the patient has when it's in these particular nursing facilities, these skilled nursing facilities.
Yep.
We're trying to get that information so that we can help the skilled nursing facilities provide care to its patients. It's not particularly complicated. So the whole point of this is how do we exchange data? When we went from paper records, I could take the paper record, hand it to you, Judge, you'd look at it, you'd hand it to Judge Gregory, hand it to Judge Wynn, everybody's looking at the same paper record. Now, all that information exists in a cloud somewhere in a server farm, possibly in Virginia, Judge, possibly out of California, we're not sure, but it exists somewhere in the cloud. And it doesn't look like the medical record anymore. Okay, so that chart that used to sit at the end of your bed no longer exists in space. It exists as data points in spreadsheets, in Excel sheets, in thousands and thousands of pieces of information that
So you
have
were
to be
getting
brought
this
together.
information using these bots, which, just seemed to be an efficient way to do it. And then apparently, I'm oversimplifying, the complaints come and then you back off. And you sort of cut your time in half of how much you're gonna do it, and then you continue to back off. And I alluded to the fact you brought up this data export as an alternative
We did.
way to do it. And, so you were answering the question of the 3 exceptions, which really looks to me like maybe where you're going is those are really narrow, that the overarching purpose of is for the exchange of information on it. And it seems as though counsel on the other side has really zeroed in on the manner requested exception. And I asked the questions about, well, it looks to me that they were focused on bot, but you say data export is a way to do it, and I couldn't find the witnesses from their side to say it's not agreeable. Is that really an issue in this case, is whether that contention is something that you would press insofar as whether this was something that he differentiated between unable to agree and cannot agree, which I guess takes, from his tenor, takes on a subjective tone. I'm not sure I totally agree with that, but it's, made sense. So how do you respond to that?
So let me see if I can understand your question, Your Honor, make sure I'm answering it.
Well, just go to the bottom, make it simple, the last part. Is it something that met that exception because it could not be agreeable? It was not agreeable.
So the short answer is counsel is incorrect. The manner exception is not applied the way that PCC wants it applied. It is not applied that way. And here's why we know that. PCC wants to use the manner exception to say we can control content. That's what they're doing. They dress it up and they make it sound like something else, but what they're really telling you, Judge, is they want to control the content of what my client can have that's part of the electronic health patient's record.
Well, no, hold on. That's obviously false. They're saying you can get any record you want from us. You just have to have a human being do it. I don't care what records you want. If you want oncology records, if you want asthma records, if you want records for this person, you're allowed to get any record about anyone. You just can't use bots to do it. That's not about the content of what they're trying to get.
It is when you put it in terms of using the bots. Absolutely it is. So you, Judge, let me, again, if I can
I guess what I
answer-
say, let's take a record. Here's a piece of paper.
Sure.
They say, you can get this piece of paper. No one is saying you can't get this piece of paper. And what's written on this piece of paper is utterly irrelevant to your ability to get this piece of paper. You just have to do it yourself. You can't use a bot.
Okay.
How is that
and
content-based?
Where does it say that in the manner exception that I have to sit there with 700 people every day for 24 hours a day to pull down information that's in an electronic health record that you maintain in an electronic format that you won't let me have because I'm your competitor?
Sure, there may be good reasons why they shouldn't be able to do that. I guess what I was reacting to was how that is in any way content-based.
Because it's content-based because the way they want to give me the information is only certain content.
Okay, well,
No,
let's posit I just disagree about that. Can I ask you a
Well-
different question that's been bothering the heck out of me about this case?
Sure, do you want me to answer Judge Wynn's
I'm
question
sorry,
first?
I'm
or-
sorry, I thought you had. I apologize.
Go ahead, Judge. I'm
No, go
enjoying
ahead. I'm going to switch topics.
Okay.
Judge?
Proceed, please.
Do you want me to?
Yes, please. That's
Okay,
my question.
so if I can get back to, I think where you were going, Judge Wynn, is at bottom, the manner exception says you have to provide the information in a way that you can provide the information, right? So the manner in which you provide information is not content, Judge Hayden, it is manner. How do I get it to you? Do I get it to you through a data export? Do I get it to you through some other magical file way that the government has come up with? What PCC wants to do is jump over all of that and not talk about whether they can or they cannot provide it in the manner we requested and get to but we have to agree to it.
Well, in fairness, the reg is written in the disjunctive.
The reg is
It says they
written in the
can't do it,
disjunctive.
or you can't reach agreeable terms to do it.
Okay,
Those are
and then-
disjunctive options.
Understood, but you can't jump over the way that you give it to me and get to the, we just won't agree with you because you're a competitor, we don't want to give you the information.
Okay. So again, the thing that has been bothering the heck out of me since I've read all the briefs in this case. So your brief on page 12 refers to the authorized automated users. Authorized by whom?
The skilled nursing facility through its agreement with the patient.
Okay,
Patient
but
comes
the
into
skilled,
us-
but hold on, but the skilled nursing facility has a contract with PCC, right?
Yes,
And when your client accesses that information, it is doing so essentially as an agent of or on behalf of the skilled nursing facility, right?
we are a BAA, a business associate. We operate under a business associate agreement, which is under HIPAA, which is,
Okay, so you have no legal right to access that information except that is derivative of that of the skilled nursing facility, right?
yes, we
Okay.
don't dispute that.
Well, okay. The skilled nursing facility's contract with PCC forbids the use of bots. Why isn't this a breach of contract every single time you do it?
Breach of contract between whom? The SNF and PCC?
Yes.
PCC has never sued a SNF for purposes.
No, I'm just saying, but I go back, it just what jarred me when I read that line in your brief, authorized automatic users, like, they're actually unauthorized automated users, because the only contract that gives you the right to access this information forbids the bots.
No, you have to separate out the words. Authorized means I have authorized access to the information. We're working in a little bit different context than perhaps just using the colloquial sense of the word authorized. Authorized means I have the right to access the patient information.
So
That's
just,
what
okay, but
authorized
just be clear, a necessary implication of your argument is that your client has a right derived from somewhere
means. Skilled nursing facilities contract with the patient.
to violate, no, because that contract forbids bots. So your argument must be that you have some sort of right to disregard the terms of the contract between the skilled nursing facility and PCC, and I don't see you arguing that, like, and maybe you can, look, people can write all kinds of stuff in contracts that's legally unenforceable.
And that's our position, Your Honor.
But based on what? You haven't alleged, there's nothing in your submissions that explain to me why that contractual provision is illegal.
It's illegal because of, and if we go back to where we started, which is the Cures Act, you can't block. How is it that you're allowed to block the use of automated users, right? They don't block all automated users. So let's be clear about that, Your Honor. That was made clear during the two-day evidentiary hearing. PCC doesn't block every single automated user that
Well,
goes
hold on.
into its system.
They don't use CAPTCHAs. It is, as far as I know, it
No,
is true.
that's not true either.
Okay,
Okay, so we're in the same space.
yep.
PCC allows automated users on its system.
Tolerates or, so I think there's a difference between tolerating something, people tolerate all kinds of things that are not officially allowed.
Every day I do.
Sure, as I'm sure I do too.
Yep.
But that's not saying that it's allowed. It's saying that people decide that it's not worth it insisting on strict adherence to all the rules for all the people all the time.
Okay, so then why only here in this case, when you're dealing with a competitor, when you've breached the non-disclosure agreement, do you come in and enforce a policy you've never enforced before, according to them on the witness stand? Why?
It depends.
It depends on what? That's a very lawyerly letter, answer.
Sure, and the way this works is that I ask you questions, you don't
I
ask me
understand,
questions.
but it was more rhetorical than anything else. Because where we are is, we have a manner exception. Going back to what Judge Wynn said, you have a manner exception. You can't simply ignore that you can export the data as it was requested. We went to them and said, we'll take the data in a data export. We'll take it in a download. We don't ever have to access your system ever again. So why, Judge Haytens, would they not give me the information at that point?
Well, let me ask you, Judge Hyten brings up an interesting point when he says, well, you could do it with the humans. The contract does, you have to interpret it in light of the Cures Act. And you started out because that earlier question about well, where do the exceptions come in, and you went to the overarching purpose of the Cures Act. And it seems to me that there could be a question of, you could say you can't get it in certain ways, but it offends the Cures Act. Because the Cures Act has a greater purpose. And I think all of us, whether we know it or not, probably benefit in some way from the Cures Act, because that's what Congress did. They didn't want people going in a corner doing things and wouldn't share information that would result in what the Cures Act has effectively done, and that is allowed probably more people are living today as a result of the Cures Act, a lot more people. And it's because this whole business, this world we're in now, and we're about to get in another world too, with data exchange.
I don't have enough time for that,
That's a
Your
whole
Honor.
nother story. But this world we're in terms of the Cures Act, and that's why I'm struggling with Judge Hyten's point that, well, humans can get it, you can get it, so therefore you meet it, but there has to be some connection in terms of, well, we're with the Cures Act. And if the Cures Act allows this, and this is a means to do it, and that's why I brought up the data export, which I do want you to sort of tell me, because, and you know, do it in light of his answer to me on that, because that's important to me. I understand now you do ask for the data export, it brings in a marketplace, which is a lot of, I don't know how you limit that. And that might be a consideration, but you know, it seems to me, this whole business of unable to agree and cannot agree, if you wouldn't need unable to agree if you could just do cannot agree, because you just wouldn't agree.
And that's what they did. That's what they did to us.
I don't think that's that narrow of interpretation on it. So, yeah.
And that's exactly what they did to us. They came to us and they said, actually, they didn't even say anything. They just stopped negotiating with us and imposed indecipherable captchas. I guess that was, you know, what the kids call ghosting or gaslighting or whatever words you want to use. There was nothing further coming from PCC with regard to any type of negotiation over terms. They told us, my way or the highway, here's the agreement. The agreement doesn't apply to this situation. They recognize that, but you got to sign it anyway. The agreement that they wanted us to sign would not have allowed us to compete with them. How am I supposed to sign an agreement, Your Honors, that says I'm not allowed to compete with them when in fact all I do is compete with them? It made absolutely no sense, and yet PCC would not entertain discussions with us to figure out alternative methods. Thus,
Can I ask you about what I view as their central attack on the district court's
Sure.
legal reasoning that
Absolutely.
I candidly didn't see a very clear response to in your brief? So let's assume for the sake of argument that the relevant language in the manner exception is cannot reach agreeable terms with the requester. That the most important, that at least one central question in this case is, what do the words cannot reach agreeable terms with the requester mean? And I view their central argument as being the district court's fundamental error is saying that an unreasonable refusal to agree to reasonable terms proposed by the other side precludes a determination that you can't reach agreeable terms with the requester. And their argument is that is a misinterpretation of what the words cannot reach agreeable terms means. What is your response to that? Because I don't really see a response in your brief to the argument that that is just wrong about what the words cannot reach agreeable terms means.
So I don't think I can say it better than Her Honor did, in her opinion, honestly. But to answer your question.
What I read her as saying is, the district court, excuse me, what I read the district court as saying is they unreasonably failed to agree, ergo, they cannot say that they cannot reach agreeable terms. But with respect, that is not an argument engaging with what those words mean. It is a factual statement about the world and then an assertion that that factual statement about the world satisfies this definition.
Okay, so then I guess we have to go to, well, what does the word cannot mean, right? That's what you're, is that what
Cannot
you're
reach agreeable terms with the requester.
You're-
And so their argument is, it can't be simply that when the parties do not agree, and when one person or side could allege that the other side's refusal to agree was unreasonable, that those words aren't triggered. And they say, well, every time the parties don't agree, it's because they can't reach terms they can both live with. Like, that's literally every failure to agree ever. And you could always say after the fact that one of the sides was being deeply unreasonable, and maybe they were being deeply unreasonable. But that's true in every negotiation. Like, if you say, I'd like to buy your house for $10,000, and I say no, and you say, but here's a Redfin listing, and here's the tax assessment, and your house is actually only worth $9,000. So I'm actually giving you a great deal. And by the way, wouldn't you have lots of great use with that money? And like, you could prove that you're offering me a 200% premium on the market value of the house. And I can still say, no, I don't want to.
Okay, except you just posited an example that does not fall under the Cures Act. So.
No, but you could equally, under the district court's theory, you could equally say the person who insists on receiving $1 million for their childhood teddy bear that would not be a situation where the parties cannot reach agreeable terms about the sale of the teddy bear.
And I'm going to disrespectfully disagree with you, Your Honor, because what you're positing has nothing to do with whether or not I am exchanging information.
But it has
that
to
the
do with what
Cures Act.
it has to do with what the words cannot reach agreeable terms mean.
Sure, and that's what I asked you. You're putting your thumb on the word cannot. And so the word.
I'm just asking what the words cannot reach agreeable terms mean as a matter of ordinary usage.
In ordinary usage, I don't know that I can tell you. In terms of the Cures Act, I can tell you what it means. And here's what it means. If you don't reach a solution under the manner under the manner
Right.
exception, you then turn to 171-205 Health IT Performance Exception. And it says that if you can't reach a reason.
No, we're not under health and we're under the manner exception right now.
No, I'm sorry. I apologize. I went too fast. If you cannot reach an agreement under the manner exception.
Yep.
Okay, then you turn to the health IT exception.
This is the cross-reference in B1 or B. There are exceptions, right? They're saying if you can't do that, then a variety of things happen.
Right, and that's the variety of things that happen.
Okay,
You gotta go, you gotta move on.
Sure,
You just
right.
don't stop and say,
Agreed. No, totally.
hands up, we couldn't reach an agreement, we're done.
100% agree.
So the fact that that's where they want to stop the discussion and where your example stops is there's nothing further to go to. Well, that's not true. Under the Cures Act, you got to keep going. The Cures Act doesn't simply allow you to be an electronic health records platform, hold all of a patient's information, and then dole it out on terms that only you think are.
But except the district court stopped with the meaning of those words. My point is the district court said the way I interpret the words cannot reach agreement, those don't apply. As a result, so you're right. Maybe, you could get this relief under those exceptions because maybe what they did after that is unreasonable. But the district court said, I can just cut this whole thing off because they're not eligible for any of that stuff because there wasn't a situation here where the parties cannot reach agreeable terms.
Well,
That's what the district court said.
but the district court actually goes to and discusses the health IT performance exception. She doesn't just.
But not in the course of the manner exception. Her discussion, the district court's discussion of the manner exception begins and ends with the statement, the parties were not unable to reach agreeable terms, ergo, the entire manner exception is out the window because it's not triggered in the first place.
Let me ask you this. It's in terms of where Judge Hyten is going with this and you are going back on it and you're using the word cannot. I don't know why it is to me. I think about growing up, you're often admonished for saying, can I do something as opposed to may I do something.
Fair.
And your interpretation is coming more from the may, more from the can as opposed to may. If it's may, you get permission, you do it. If it's a can you do it? Well, if it's an idea, yeah, you can do it, but you cannot do it because you won't do it. That's kind of the way I'm seeing you going with this. That you put out a way it can be done, but it cannot be done because you won't do it. And if we're going to go back and forth on that, then I don't see a reason for the first language, as I said, unable, because you do that in every case. Says I just ain't gonna do it. I'm not gonna do it.
And that's exactly right, and that's exactly what happened here.
Ain't is my North Carolina word for that.
You can use them all you want, Your Honor, I understand them. So I just, not sure, my time is up, so if there's no further questions,
No, I'm good.
No, we're good.
thank you.
Thank you,
Your
Ms.
Honor.
Bruce.
Oh, I'm sorry.
Yes,
Sorry,
go
Judge.
ahead,
Can I ask one other?
If I said no, does
I
that matter?
apologize. No, and that's about, let's put it, because there's this language in your brief where you say, like, okay, put the Cures Act. So there's the question of whether you can get a preliminary injunction or relief for a violation of the Cures Act. I guess there would be a question whether you could get relief as a matter of Maryland law completely independent of the Cures Act. And then there's a question about whether you could get relief for like a blended, like some Cures Act, some Maryland law. Do you agree the district court's PI in this case that we're currently reviewing is based solely on a violation of the Cures Act?
Yes.
Okay.
I don't disagree with that. We put that language in the brief because.
No, I understand, yeah.
Yeah.
To preserve it for future
Yeah,
proceedings.
and it's also clear Maryland law doesn't require there to be a statutory violation.
Yeah, but it's just, we're on an interlocutory appeal
Yeah,
of a
no.
preliminary injunction. The preliminary injunction is based solely on a violation of the Cures
No,
Act, right?
I
Okay.
don't have a fight with that. Your
Okay,
Honor.
thank you.
You're welcome.
Mr. Byland?
Thank you. Your Honor, happy to go back to jurisdiction. Just wanted to say at JA 9, their complaint, in the title of their complaint, they represent themselves that they're an incorporation. We haven't yet had discovery. I take it from her representations that she's not contesting this jurisdiction, so happy to answer any other questions you have on that. I think you hit it on the head. We have a contractual prohibition, and the judge recognized that the only way to get around the contractual prohibition if there's some violation of the Cures Act. It's the only thing that could cause that contractual provision not to use step by.
I mean, the contract provision could conceivably violate Maryland law. I mean, theoretically it could.
But the only thing that the district court recognized
Yes.
was a violation of the Cures Act. And so because they can't satisfy a violation of the Cures Act, the whole thing falls apart and needs to be set aside. I wanted to, Judge Wynn, I wanted to try to be responsive to your concerns. So when you're within the manner exception, it's not that they don't get what they want. It's just that that has to go through the content and manner standards.
See,
of
the
Part
basis of it is really not cannot reach an agreement. It's cannot reach agreeable terms. That's the term that's bothered me, is that agreeable term. What the heck is that?
So-
I mean, when you think about, if you cannot reach an agreement, well, you can't reach agreement because you won't agree.
Correct.
But could you reach agreeable terms? It's really fuzzy. I mean, I don't know what it means.
So to the extent that the court has a concern about Matt, maybe it's ambiguous, I would point the court to the ONC's explanation of it, and then I would probably rely on Kaiser to defer to the agency. It says, we see actors who are experiencing a problematic level of uncertainty about whether they will be engaging in information blocking if they decline demands from requesters for non-standardized or non-scalable solutions that they do not currently support. And then they make clear that when you offer and this is at 89 Federal Register 192 at 1381, and they make clear at that point that you don't have to agree if it's non-standard and it's not scalable, and in the alternative, you can provide the reasonable alternative. So I think if there's fuzziness in that language about what it means, I think ONC has cleared it up to say that there's no thumb on the scale that we have to agree with their terms if it's non-standard, non-scalable, and we don't want to agree to it.
Do you win if we don't apply any of the exceptions, including the manner requested or the health or the security? If they don't apply, would you win under just the application of the CARES Act?
I think that on our alternative argument, I think we win because it can't be a predicate for Maryland state law claims. If you're asking me if we can't use the part of the definition.
Assuming we said it could be, would you win under the CARES Act?
If you said it was
Yeah.
information blocking, then we would say we would win because the Cures Act can't be a predicate under Maryland law, under the tort. And we also have the argument in our brief about the standard or the burden of proof being improperly shifted.
You've also got a real big swing takings type argument too, right?
So I think the takings argument is more just a constitutional avoidance argument, right? So the reason that there's a fees exception and a licensing exception in the Cures Act is so that you're not co-opting our private software. And so my point is if you disrupt that and you're not allowing we're not getting any compensation from RTMS.
No, I just thought through the implications. I was thinking, like, this is a big thing in the early 2000s, right, about the deregulation of the telecom industry and requiring the legacy carriers to give access. And, like, no one seemed to think that to the extent they argued that that was unconstitutional, that did not succeed, right?
It's true, but they weren't receiving $0, I guess, for unlimited demands on their software. But it's more of a constitutional avoidance argument, not a direct argument.
Just to be clear on that, I'm gonna leave data exports alone, but just answer this for me. Are you saying you don't support that for any users?
Bot access, Your Honor?
No, data exports. Do you support the use of that by anybody?
Not in the way in which it was described to us on sending CSV files. What I will say is that there was testimony that what we could provide is a data relay where we'd make a copy of all the data and we send it to the customer, and then the customer could give that to RTMS. And
So you're saying there is some method by which you could agree, but it's not this?
Yes, so there's a method we could agree, but it puts cost on RTMS, and they want to put all the cost on us. They want us to format the data and send it. They want us to allow bot access. What they don't want is us to do a data relay package and send that to their client, because that would put a burden on their client. I would refer you to JA 516, where their witness, Chris Miller, said that would be a burden on their customers. I would also refer you to JA 644 to 645, where our witness talked about how some customers have contracted for this entire amount of data, the follow-up questions at issue, to be exported to the customer, and then RTMS could get it. But again, they don't want to do that because it doesn't put the cost on us, it puts the cost on them.
So there is a benefit, I take it you get, when, even when they use bots, is they pay for that or not?
They don't pay for bot usage.
They just use it?
Yes.
Free?
And it's costing us money. This injunction is costing us money because they're using our server space that then can't be used by our
Is that
customers.
because you all got the same kind of, how's it work? The people that are giving you permission, the patients, it's
So we-
all, you're serving that entity, not your own.
If I might answer, I'm out of time.
Sort of parasitic, isn't it?
So, yeah, they're very parasitic. So we have a contract to provide manual access to nursing homes. And the server space that we have is designed for that manual access. What they're doing is overloading it with bot usage, costs us a lot of money, causes disruptions, causes outages, and all sorts of issues. And that's why the manner exception exists, to say, look, you get it this other way. And I guess the last thing I would leave you with is the manner exception does have a content. If you look at Part 170, it does have like some content restrictions. But to your point, they can get every piece of data through human use. So I'm over time.
All right, thank you, counsel.
Thank you, Your Honor.
Thank you both, Mr. Ballard and Ms. Bruce. We're gonna ask the clerk to adjourn the court until tomorrow morning, then come down and greet counsel.